your pleadings or your application is perfect. No, just show the examiner. So for instance, let's say it's a question testing issues to do with order 39. Yeah, arrest and attachment before judgment. Examiner just wants you to note, okay, you bring the application. What are your orders? Yeah, take notice. You've done that. Then your orders for orders that A, this matter be certified urgent. B, that you just craft the orders based on how they've been written down in the statute. And if the examiner says that, you get your full marks. So the issues of like trying to make it complex or trying to perfect it during an exam setting, no, it wouldn't arise. Do it as fast as you can, move on to the next question. Because trust you me, time is a factor when it comes to civil. And you'll see when you do the paper, most of you will finish the paper without having answered all the questions. Okay. So make sure you allocate time well. And then the other thing before we begin, always attempt all questions. Don't leave any question unanswered. So the exam paper will, let me project one. So let me project this paper here. So this is the exam paper. You're told candidates must answer 5 questions. Question 1 is compulsory and carries 20 marks. So you have to do question 1, that's compulsory. 1, 2, 3, 4, 5, 6. There are 6 questions. You're told to do 5. Make sure you attempt all the 5 questions, all of them. Don't say, I'm looking for 20 marks, and then you do question 1 perfectly, you do question 2 perfectly, and then you do question 3 perfectly, and then say, again, italala. 4 and 5, it's not a must. I personally believe there's a vendetta or there are penalties for not answering all the questions, and that may actually affect you. You may even find that you're looking for 20 marks, but then you get a fail because of that. So make sure in Atakama Hojui, just do it. Craft whatever you can craft, draft whatever answer you can draft, but don't leave any question. Don't leave any question unanswered completely. Same goes with number 1. Make sure you do number 1. Okay. I can give an example with legal practice management. Yes, legal practice management. They brought a question which was not even in the syllabus. It was an income statement for a corporation. So in the syllabus, we've been taught partnerships and we've been taught sole proprietorships. But they brought an income statement for corporations. Didn't have any idea. Completely zero. I didn't know anything. I didn't know how to work that question out, but I knew the basics. I knew how an income statement should look like, and I knew what to put where and what to put where, and that's what I did. I didn't balance it out in the end, but I attempted the question. So that's really important. You need to note that and make sure that you at least attempt all the questions. So other than that, those are the few things you need to note when you're doing the exam. And then maybe something else. I don't know if people have told you, but during that exam time, rumors will start flying all over that, I have a leakage. I know that there's a paper. I have the paper nimetumiwa. I know somebody from CLE. There's actually a very popular one I was actually a victim, I think a week before exams, people are saying the Strathmore people have the paper, which was completely false. But, the time people are panicked, and now you're like calling all your Strathmore friends. Kuna karatasi and you're not even telling us. You guys know what is coming in the exam. Why aren't you telling us? And then there will be fake papers flying all over. Truth of the matter is, nobody has that paper. No one has that paper. And I can attest. Last year when we were doing the exam, people would, like before the exam room or maybe the night before or even the morning, people will come and say, hey, nimetumwa hii karatasi. None of those papers came. None. No paper leaked completely. No paper leaked. So nobody has those papers. Don't be lied to. Don't invest heavily on trying to read those false papers, because I can assure you and I guarantee you nobody has those papers. So if you go into the exam room, it's just you and your mind. Okay, so don't invest. Don't remove your money. Don't, everything that comes with the exam pressure. And all in all, you will pass. Maybe before you go on to do civil, anyone has a question revolving the exams? And, because, the thing about exams is not even your knowledge, but how you approach, how you answer the questions, and how you go about it. So, anybody who has a question revolving on the exam, like the climate, how you do it, how it is. And if no, do we proceed to begin? Yes?
Maybe you can tell us
Excellent.
how you manage to stay calm throughout
Okay.
the preparation and the study the whole exam season. Because I
Okay.
think the challenge most of us are having is you've read, you've been attending classes, but then now you get now to go through the past papers and you realize that if it's a question of 10 marks, you're not able to score even half of the marks.
Okay. So how you stay calm during the exam time, or
Yeah, before the exam and during that time.
okay. Now, the truth of the matter is you will panic, you will be scared, you will be frightened, you will feel anxious, and it's a fact. It happens to all of us. It happens to me. It happens to my friends. And okay, a week ago I received a call from KSL. I topped in conveyancing, so they told us to attend graduation and then we'll be given awards. So I'm telling you from a personal experience, and I did very well in my papers. So there is it. Before I went to do the papers, I was frightened, I was scared, and I was panicked. It's a fact. It's something that's unavoidable. But at the same time, it's you just tell yourself, it's just a process. It's a process. It's something that you have to do. You have to master. You have to garner courage. So, in as much as I was scared, there was a way I could conceal it. And some of the things that assisted me with, just relaxing was having adequate sleep. So I would finish the paper. I would go home and I would actually sleep by 9, 10, find myself asleep, and then I wake up at 5, prepare, go to school. Having adequate sleep, eating well is also something that will contribute to your health and also to your mental, like your mental health and so forth. The other thing is exercising. So for me, I used to love swimming. So after the paper, after we've met with guys, tumeongea, talk about how the exams were hard, how imetulemea, imetukalia, I will go find time and maybe swim 30 minutes, and then go back. And then dedicate at least maybe 1 hour, 2 hours just to go through the few things. And then in the morning, I will dedicate in between from 6 to from around 7 when I go to school, meet with some few friends and then discuss, talk about these, the things that maybe we didn't cover very well adequately. And those last minute discussions help. So that's how I used to do it. I didn't overthink the exams. I didn't overthink the, papers. I didn't put pressure on myself. I flowed. Usisome at the same time usikae and then you don't sleep at night. People were there. Okay, there are some people who translating works for them, but it's good for you to know yourself. Don't read the entire night. You need to be fresh. The people there's a way they craft those questions. They need you to be innovative in how you approach them. They need you to be creative. They need you to be in your mental, in the proper mental, capacity to answer those questions. Because the way they may fix that question, you don't even know what the issues are. And if you have a tired mind, you won't be able to address those issues very well. So just sleep well, eat well, exercise a bit, and you'll be good. And that should start as early as now, not when you're doing the paper, but as early as now. And you will pass. On the issue of getting scared, but even the person who will be the top student in your year, the persons who are going to lead in the units, the persons who you say are extremely brilliant, extremely sharp people. Same people are also scared. It happens to all of us. Everyone's scared. Even a professor is. Even Mrs. Mongari, you tell her that tomorrow you're going to sit for a civil litigation paper, she'll panic. Omosa, you tell her that tomorrow you're going to sit for a criminal litigation paper, he'll also panic. So it's a normal process. Don't be scared. It's something that happens. You just give yourself hope, and then it's a normal paper. Actually, it's a normal paper. You will find that you've encountered harder papers compared to what what is being tested here. Because personally, undergrad, there are units like public international law, things like international trade. They are more complex compared to what you're doing right now for the CLE exams. Is that fine, Cynthia? Okay. Kimani, your hand is up. And then there was a gentleman who was talking, but I can't see his hand. So please, you can unmute after Kimani. Kimani, go on.
I think it's a long. I think you partly answered my question by talking about sleeping enough hours. My question relates to how many hours did you read per day? Because the problem I'm having with right now is knowing whether I've done enough. So at times I've had people saying they do at least 11 hours continuously. For me, I need breaks in between.
11 hours.
I hope you can hear me.
Yes,
11 hours can be okay.
Yeah.
At times I get so exhausted and I'm suffering from the guilt of knowing whether I've done enough. And how did you balance group work versus and personal reading? Because the other thing I'm struggling with is being in panic mode, and I want to join almost every group discussion, which is making me a bit overwhelmed.
Okay, that's fine. So now, how did I balance the same? So I will dedicate at most for personal studies at most 2 hours in a day. That's what I will dedicate to as my study time, like personal studies, where I revise for myself, go through my notes, try and remember a few things here and there, so forth. 2 hours. Then during the day, you will find guys meeting up, discussing. The other hours now will be spent in maybe group works, farm work, and so forth. So for me, I didn't join many groups. I just had a friend of mine. Do you know Alex? We were very close friends with Alex. So we will study Alex and a friend of mine called Titus and I. We will dedicate just a few hours before the night, like an hour. We study and then that's it. So the thing about study hours is dependent on the variable of you knowing yourself. So you need to know yourself, how much or what is your concentration span. My concentration span is not that long. I just concentrate for short periods of time, and that's enough for me. But there are others who can do it for long durations of time. So it depends. I can't tell you to read for 2 hours or 1 hour or 45. There's somebody who will read for 30 minutes and they're okay. Others will do it for 11 hours and they're okay. So it depends on the person. So for me, I would spend 2 hours, at least at most 2 hours for my personal studies. After the 2 hours for my personal studies, I will now go on and listen to guys discuss. And even if I'm not contributing, just listening, because there's something they may talk about and then the same is brought in the exam. Or maybe, actually, another thing about group work is just don't go to there to listen. Go there and also contribute. So whatever you read, go there and try and replicate. Yeah? And that will assist you. So study habits. What is my study habit? Don't read notes. Okay, it's a caveat. Don't read notes like for the first hour, then you read the same notes for the second hour, and then you read the same notes for the third hour. That's like cramming. Yeah? So open a book, read, for instance, a chapter on reviews. You've done reading, you finished reading reviews, huh? Close the book, then try and remember what you read. Write it down. Reviews. Where is it found? Section 8 of the Civil Procedure Act. Where else? Order 45 of the Civil Procedure Rules. This and this happens during reviews. Which application do you draft for review? This is the application you draft for review. And you're done. That's better compared to you studying, for the first hour you've done reviews, then so unafunga kitabu, you open again, you start reading for the same things on reviews. It doesn't help. And then practicing your drafting skills. You don't need to practice just A notice of motion application is a notice of motion application. A chamber summons application is a chamber summons application. A plaint is a plaint. Not much will change. Huh? So the only thing that you need to know is the law. So for instance, if you know how to draft a notice of motion application and how it applies, the only other thing that you need to do is now check what are the instances where a notice of motion application is used. So actually you should have that thing in your, if you're revising or you're studying for civil, you should have a section. These chamber summons are used in this manner. Notice of motion application is used in this manner. OS is used in this manner, and you'll be good to go. So, if you know how to draft a notice of motion application, you're good to go. The only thing that will change is now, let's say the prayers. If you're bringing an application under 39, prayers will be different from the application under order 40, and the grounds are also different. That's the bit of it. So that's what I will do with my personal studies. 1 hour, okay, or like 30 minutes, read something else, and then now badai, I try and now remember, what was I studying? What can I remember? What is this? How does this apply? And you'll be good to pass. You'll be good to go. Yeah.
Thank you.
Okay. Anyone else with a question? Okay. Now, I think we'll begin. But I can see Lavince is in the meeting. Lavince, do you want to say something before we now start the questions, the civil litigation questions? Okay. I can't see him, but guys, we can now begin so that we can see if we can finish early. This civil. Hey.
Yeah, just a quick one.
Yes.
Will you advise that when tackling the questions, will you advise that you begin reading the question from reading the specific part where they're asking you the question? For instance, if the question is a bit long, you start by reading part A, then you go back to the facts of the question.
Yeah, it's totally fine. I do that all the time. You may find, okay, you've been given an exam paper. The first few minutes you use to read the questions and see what is in the questions. Huh? So at that time, you can just go and look at it, because you see, let's see if I can open up. Okay, that one doesn't have, let's see, A and B. Okay, but there are some questions where part A will actually sell itself out, and you'll know that this is what is being required here, and then this is what is being required here. It's fine. But at the same time, you still need to go back to the facts, because the facts carry a lot of things, and there are some hidden things that are in the facts that you will need to pay particular attention to. So yeah, it totally works. You could do that and then now go back to the question. You could start with the question and then follow it systematically. There's no formula for this, provided you've understood the questions and you carefully analyzed and just approach the question in a legal manner. That's fine, Arunga. There is no specific formula. The way you do it, provided you've understood and you've analyzed the question well. Yes? That's fine, yes? But can you hear me? Am I audible enough?
Yes, you are.
Okay, that's fine. Now we can begin with. So I'll be taking down some short notes here as we speak. So somebody please read for me. So I can't see who's raised his hand or not. So just unmute and talk. Someone can read for me number 1. Then we can begin. Number 1, please. Yes, the question. Number 1. So I chose. Okay. We chose to do.
You have recently been retained as a pupil at the firm of. Sorry.
Can you see now?
What year is it?
This is 2018. Guys chose 2018. So the November 2018 paper we had already done. Then guys wakaongelelea this was a bit challenging. So it's a receipt paper. Typically receipts are very challenging. If you can pass on the first go, pass. That's many people responded with this paper. That's why I've chosen it. But if you have a question from another past paper which is relating to it, feel free to unmute and ask the same. Okay, please go on. Whoever was reading.
You have recently been retained as a pupil at the firm of Xavier and Company Advocates, Y Plaza, PO Box 24, Ubungo, and in your daily tasks in the firm, you take down the following notes. Dan wants a case lodged in court. He was involved in an accident where he broke his left leg. He complains that he suffered loss as a result of the accident. The driver, Derek, was blamed for the accident of the motor vehicle registration number KBS 149A, a bus in which Dan was a fare-paying passenger. The driver was blamed for driving the motor vehicle dangerously, reckless, or negligently. The motor vehicle was also found to be in an unroadworthy condition. The accident occurred on the 20th November 2004 in VMAX district in the Republic of Kez. The vehicle belonged to Mary, who resides within VMAX district. Derek is still working for Mary. Her office is located at Palm Plaza. The address is PO Box 124 Ubongo. There are several documents in the file related to the case. A discharge summary sheet from the hospital showing nature of treatment, medical receipts amounting to 70,000 Kenyan shillings, transport receipts for the cab company totaling 30,000 Kenyan shillings. There are also receipts amounting to 20,000 Kenyan shillings as evidence of money paid to a house help who assisted Dan during the time of recovery. Dan has already been referred to a medical expert who has charged 5,000 Kenyan shillings for a medical opinion. The receipt is available in the file for that. The medical report is also ready. Jaden, who was a passenger in the bus, is ready to testify in support of Dan's case. All witness statements for Dan, Jaden, and the doctor are ready. A demand letter is also in place, but there has been no response thereto. Draft the appropriate pleadings, seeking the necessary remedies in court and state documents, if any, that should be filed together with the pleadings, 20 marks.
Good. Now, that's a fairly easy question. You ever done a question that's similar to this one, an accident case? So, in the spirit of moving faster, then now, so that if there's any other past paper that you want us to tackle, we can have a look at it and then I can guide you on the same. So we can prepare. So let's just go through this one first. So what do you think? What are the documents that are going to be filed in this case now?
That's a plate, Salonka.
Go on.
Accompanied by a verifying affidavit. And then, since you are told to state the documents that are going to accompany, you can you include a statement of the plaintiff list of documents, and also the plaintiff list of witnesses.
One other thing, the statements.
Yeah.
So we've identified these are the documents that need to be drafted. Yeah. So there's a mark there. So the question is saying draft the appropriate pleadings and state any documents. So they don't want you to draft all these. They just want you to draft the appropriate pleadings, which will be the plaintiff and the verifying affidavit. And then now you just list these other documents. And you've secured your marks. Now, in this question, the other things that they check, there are some small details that they check. other than the pleadings, we need to ask ourselves, which court will this thing be filed? Which court? Somebody?
Magistrate court.
Magistrates courts. Here you have your marks. The other thing, under the civil procedure rules, framing and institution of a suit, order 3, what else should you pay attention? What else should be listed in your pleading? It's a very crucial 2-word
The
thing.
party.
Okay, the parties. Okay,
The
let's go,
party.
let's go to parties first of all. Okay, parties, yes. Parties. Who are the parties here?
The driver and the owner of the motor vehicle.
Uh-huh.
Those will be the first and the second defendant. The driver being the first defendant, and the owner of the motor vehicle being the second defendant.
Uh-huh.
And Dan is the plaintiff.
Now, good. Everything's going on well. What else? Even before now we go into the plaint, what else has to be there?
The case track.
Yeah, I explain more on the case track.
Whether it is a small claim, fast track, or multi-track.
What's the difference between the two? Because we're revising. What's the difference between all those three? Anybody can contribute. What's the difference between a fast track claim, a multi-track claim, and a small claim?
A multi-track claim is one of there are complex matters, and it takes a period of 240 days. And then for a fast track, it is 180 days, and there are no complex issues. And then for small claims, it depends on the amount, which is the money should be below 1 million. So this is a fast track.
Sorry, I was talking while I was unmuted, while I was muted. So now we've identified the proper tracks. The next step will be now to draft the plaint now in itself. So what do we draft? What does the first paragraphs entail in a plaint?
You need to describe the parties.
Describe parties, yeah?
Yeah, so you would say, not gotten the exact names of these people, but you say something like the plaintiff is, just describe the parties. You describe the plaintiff and the respondent in the second paragraph.
Yeah, plaintiff and the defendant, huh?
Oh,
the plaintiff and the defendant, yes. So another thing is the names, huh? So you need to be careful with the name. So if it's a plaintiff, defendant. If it's an application, applicant, respondent. If it's a petition, petitioner, respondent. What else? Yeah, that's it. So let me just show you a sample plaint that we did with you guys a few weeks ago. This is an assignment I did in class with Mrs. Mungari. She gave an assignment, so I did it. So there's a plaint. You've done the plaint, you've identified the track. The heading should look like this. Paragraph 1, 2, you describe the parties. 3 and 4, now you give the facts. So this is a plaint for breach of contract. So plaintiff claims damages despite demand and intention to sue having been given the defendant. So these are other crucial bits of the other crucial bits of a plaint, the last paragraph now. These ones have to be there. Demand was given, the person has failed to hit the demand. There is no other suit pending. There has to be no previous proceedings in any court between the plaintiff and the defendant over the subject matter. So this is the aspect of res judicata and sub judice, section 6 and 7 of the Civil Procedure Act. And then the cause of action arose within the jurisdiction of this honorable court. And then reasons wherefore the plaintiff prays for judgment against the defendant, you have to identify. So what you guys will do for me right now is identify the special damages in this case. I'm back at the question. So you need to identify the special damages. So special damages are those that are specifically quantified and can be proven. So you have the 70,000 here. You have the transport receipts of a cab company. You have the receipts amounting to as evidence of money paid. Yes, medical reports. That's another one. There's another plaint I was actually trying. This one we did. And I sent it to you. It was on Wakili Mkuu or something, June Stewart. I once sent it, but I can't see it here on my laptop. But anyways, but that's just the gist of it. So that's how a plaint will look like, and you've done. And then you finish the document by writing. You make sure you sign the document. So okay, let me just open this one here. So you've drafted this thing completely. It's perfect. You come here, make sure you sign here. I hope you can see it. Make sure you sign the document here. And then make sure you write drawn and filed by to be served upon. And then you have to put this thing in there. Okay. And you're good to go. The other one is,
a quick one.
Yes, go on.
Sorry, I don't know. There's too much echo, but on this, there's something that you have pointed out. The service of summons to be effected through the plaintiff advocate's office.
Yeah.
So in the event that you have, and this is a question that I actually raised with Ms. Mongare, in case you have the defendant's postal address, drafting the plaint, when you're doing the description of the plaint,
yes,
do you then include the details of that service of summons to be effected through that postal address of the defendant, or how do you go about it?
Okay, I get the question. Now, let's look at this one here. Let's look at this paper here. Let's look at. Now, this is it. The first bit where you're describing the plaintiff, it's simple. It's your address of the advocates, yeah? So this one, the address for the defendant is going to be the address that you've been given there in the question. You have it. You'll put it there. But service of summons shall be effected because you're the advocate who's you're the one who's going to pick the summons in court. Okay, advocates are the ones who draft it. The firm drafts it and then it's just stamped and signed by the court. So you're the one who picks it. You're the one who picks the summons, and then now you will go and serve them. So the person who's picking those things in court is you. So summons will be effected through you as a plaintiff's advocate's office. So you will have his address here. His address, for purposes of this suit, is this. This is the address. Yes. Why is this address important? Because if you have the summons, you can serve through his postal address. And the certificate of postage is what you will bring as evidence. So later on, if you're seeking for interlocutory judgments or judgments in default of appearance, that's going to be the evidence of service. Huh? So his address of service, or his address of service for purposes of this suit is this. But the summons shall be taken by the plaintiff's advocates, who will then eventually go and serve this person, the defendant. So service will be through the plaintiff's advocate's office. But this is something that you need to note. If you've been given the details of the advocates, the facts, the question has given you details of the advocates, summons will not be effected through your offices, but summons will be effected through the firms of, like what will happen now, you write here, whose purpose for the, okay, you write whose address of service for purpose of this suit is care of, then you put the other advocates' details over there. Is that clear now?
Yes. that was a very good clarification because we had an extensive discussion on that. And,
Okay.
It is home. Yes.
Okay, you're welcome. And now we're done with the question. Umemaliza, you're good to go. You've done the verifying. Do you want to see how verifying affidavit look? Okay, I don't even know if I drafted one in this, but it's just a simple, simple document. Si ngumu hiyo ya kusumbua, kutatanisha during an exam setting. And you're done. And you have your full 40 marks. So bear in mind, this is number one, it's drafting. How much time should you spend in that question? 25 minutes, at most 30 minutes. The time allocated to that question. Do you have any question in relation to this part one? And have you seen how marks are allocated? Sorry, go on.
I have a question. This question.
Mm-hmm.
I think you stated that we are going to file this case at the magistrate's court.
Yeah.
Yeah, I'm just, when I look at the claims that we have, I don't know if they'll reach 1 million, because if they don't, then we need to go to the small claims court. What's your opinion?
Okay. That's interesting.
Yeah.
That's interesting. Now, okay, there's the development of what's it called? Small claims court. The first thing you need to, when you look at the small claims or matters that are taken to the small claims court, you need to check the jurisdiction of the small claims court. It's not all claims can be brought to the jurisdiction to the what? Not all claims can be brought to the what's it called? To the small claims court, but there are certain matters that ought to be brought, and the pecuniary limit, as you rightly pointed out, is Kenya shillings 1 million. 1 million. So let's check here. Section 12. Section 12 of the Small Claims Court Act. Subject to this act, the rules and any other law, the court has jurisdiction to determine any civil claim relating to a contract for sale and supply of goods or services, contract relating to money held, compensation for personal injuries, liability in tort, property, set-off and counterclaim under the contract, and so all those things. So this is where maybe you can say, okay, now based on this, why aren't we approaching the small claims court? Or why shouldn't we approach the small claims court? But before I answer that question, let's first go to how those documents in a small claims court matter look like. Let's open the subsidiary legislation. But here it is. So okay, you may go to the farm and they tell you, draft pleadings for the small claims court. So these are the pleadings that you will draft in a small claims court matter. It's just a form that you fill the details in there one by one. Yeah? But the main reason why you wouldn't go to this is because of the aspect of open this one and you see. In as much as the 70,000 is not coming or totaling to 1 million, there's the aspect of general damages. Yeah? General damages are awarded on the discretion of the court. So, and this is a fact. You can go and check Kenya law. You will find many cases where the special damages don't even come to 20,000 or even 10,000. The special damages that have been ascertained, the medical receipts, medical report, they only total to around, let's say 15,000, 20,000. But the general damages that are awarded by the court total to about 2 million, 3 million, or 4 million, 5 million. So one thing that will make you not go through the small claims is because of a pecuniary jurisdiction. This thing they cannot award damages more than, if they award, they'll be acting out of their jurisdiction, out of their pecuniary jurisdiction. So they can do more than 1 million. And okay, yes, you may do it, and then maybe down there you're like, okay, it's more, because a statement of claim is a pleading. Yes, you can draft it and then take it to court and then argue, it's a claim for personal injury. You will still be right. But at the same time, somebody else who drafts plaint goes to court via plaint, goes to the magistrate's courts because of the jurisdiction of the magistrate's courts, will also be right in that circumstance in light of the changes to the law. So previously in 2018, you couldn't bring that one. Okay, this act is 2016 act. and 2016 Act. So you couldn't bring that claim to what? You couldn't bring the issues of settlement of claim back then because of those issues. Another issue will be the issue of gazettement of small claims court. We don't have small claims courts everywhere. Right now we have in Nairobi, and there's some few areas that the Chief Justice gazetted recently. So the thing could also be pointed out to the question, Xavier and Co-Advocates Plaza. Where is this thing located at? In, let's say, okay, Kilifi, I know there is. Let's say in Loitoktok. Oloitoktok, yeah? The court is in, it's written there, Oloitoktok sub-county. Oloitoktok sub-county doesn't have a gazetted small claims court. Yeah. So if it doesn't have a gazetted small claims court, you can bring a small claims court there. So those are some of the, some of the pointers when it comes to ascertaining which court will approach. So maybe this year they may try and say, these things, the small claims have started picking up. So let's test this thing in the exam. I think in the exam question, something will point out, and they will bring some small facts there to point you towards the direction of the small claims court, maybe on the issue of gazettement, maybe on the issue of pecuniary jurisdiction, and so forth. But as it stands here, from the facts that we've been given here, first of all, VMAX district. VMAX district. Do they have a gazetted center as a small claims court? Not sure. We don't know. But what we're sure of is there's a magistrate's courts in that center. So those are some of the things that will play. Right now, if this thing was set in 2020 and then you decide to do the statement of claim and you've done it perfectly, perfectly based on this, you followed everything here, every small detail here, and you drafted it perfectly, I wouldn't say you are wrong, because based on the jurisdiction the court has under section 12, you wouldn't be locked out. Compensation for personal injuries, civil claim, the pecuniary jurisdiction limited to 1 million, and the Chief Justice may determine by notice such other pecuniary and so on. So that's how I will explain it. It may be tested, but I think if they do that, they will point it in the question. So there's a way you can identify it from the question. Safest bet, however, will be magistrates' courts unless otherwise. There's a general rule and there's an exception to every general rule. So for me, I will say the general rule is do the magistrates' courts unless otherwise. Now, the unless otherwise is based on if the facts from the questions present themselves otherwise. Is that fine? Or does the answer make a bit of sense? Yes, go on.
Okay. Yes, Solonka, I think you have a question.
Yeah.
I'm seeing the accident occurred in 2004, and at the sitting of this paper, it was 2018. So it's 14 years later. So I don't know if we will need to seek an extension of time. Will that be appropriate in these questions as part of the things we will draft?
Okay. Yeah, I get that concern, and it's something that we also raised sometimes back then. So you need to remember that at the same time, the people who are setting these papers are human. So we don't know what's their thought process when they are setting the question. Maybe this person intended it to be 2018, you don't know, or maybe he put it as 2004 intentionally. Yeah. So there were various theories, and up to date, to be honest, I don't have an answer for that. But others will say, okay, it's brought in 2004. You can now maybe put 2005 in your pleadings, 2006 in your pleadings. Others will just ignore that completely and just proceed to file the pleadings. The reason is you don't need to okay, it's a 20-mark question. If you want to seek leave, it means you will be drafting other documents. You'll draft an application, a supporting affidavit for that application, and then on top of that, you bring in the plaint now. After you've brought in the plaint, you now draft the verifying affidavit, then now list the other documents. So to me, I wouldn't draft those documents. I will just go straight to the question, draft the pleadings that they've asked for, which is a plaint, and then maybe put in, I don't have an answer for that, to be honest. So I would maybe others say put 2005, others ignored. I'm from the school of thought who ignored. We didn't fail. So I think that's just a small, it's a small issue. But what I am sure is you don't have to draft the application to seek leave to file this thing out. Yeah.
If the question is pointing you to, if the question is pointing you to draft the pleading,
yes,
I would want to believe that an application is not a pleading itself, but a
yes, it's not
is a pleading.
Yes, yes.
So then I think automatically that should tell you that these people do not want you to look at it in the sense of seeking leave to bring this matter before the court.
Yeah, that's true.
Yes, I think that is where the trick is. From the question, they are just looking to draft a pleading and not the appropriate application. Or if they wanted you to draft the application, they have just stated that kindly proceed and maybe draft the necessary documents or something of the sort.
Yeah,
but if they are pleading, then that's a plaint.
Yeah, that's a valid answer. That's actually a valid. That's a correct answer. Plaints and pleading, pleadings and applications are two different things. They're asking pleading, so you're restricted to either drafting a petition, a statement of claim, memorandum of claim, plaint, depending on the facts of the question. Eh? So that's true. So in this case, you just go straight and do the question. And then it's 20 marks. 20 marks. 20 marks. You draft an application, then you bring a pleading. It's excessive. So yes, that's true. Somebody else was asking a question.
Sorry, mine was asking that. I was just thinking you do the pleading, then you must put in the other parts where we're supposed to list the documents, accompanying documents, maybe you could put the application for extension.
Oh yeah, or maybe you list it, yeah?
Yeah, list it.
There's even a leeway here. State the documents, if any, that should be filed together with the pleading. Oh yeah, so you could maybe go there and now explain, this thing has been, it's out of time, bring all those issues. You analyze the Limitation of Actions Act, because that's the thing that has barred these things statutorily, yeah? And then, yeah, so that's true. You could maybe go down there and now explain it, show the examiner that you know. But actually, since you've pointed that, there's something else I've remembered. How would you answer this bit on state the documents, if any, that should be filed together with the pleadings? Please, I repeat, make sure you always cite the law. I don't know why this thing is not moving. Make sure you always cite the law. And by citing the law, I mean, you come here, and when you're answering that question, show the examiner that you know civil procedure rules. Tell them, under Order 3 of the civil procedure rules, these are the documents that need to be filed with the plaint, and you list them. There you have your full marks, and you'll show the examiner that this person knows their stuff. Okay, when you're answering that bit, make sure to point out the law. So after that, sawa.
Yes.
So we go to there, yes. Now let's go to question 2. It's civil. Summer civil. It's not technical. It's a fairly easy paper. Someone kindly read for me number 2, please.
You are a legal officer employed by Granto People Company Limited, and the legal manager has instructed you to write a brief. A former director of the company, Mr. Peter James, is aggrieved by a ruling of the Employment and Labor Relations Court, which the judge declined to review and set aside a judgment delivered against the company. In the judgment, the court held that Mr. Peter James, who was not a party to the suit, had sexually harassed Mary Amber. Accordingly, the court awarded her 7 million Kenya shillings as general damages against Granto People Company Limited. Mr. Peter James has appealed the decision to the Court of Appeal, alleging that he was not given an opportunity to be heard, give a brief on joinder of parties, review of judgments by Employment and Labor Relations Court, and chances of success.
Thank you. Now, let's approach this question this way. This question is broken into two. I want you to talk about joinder of parties. I want you to talk about joinder of parties, and then part B, they want you to talk about review of judgments by the ELRC. So even before we go into the facts, let's now look at this. Joinder of parties, which provision of the law provides for this? Or the what of the civil procedure rules? Yeah, for the one of the CPR. Any other laws? Any other? Do you guys have any other provision that we may use to rely on?
So the question is touching on employment and labor relations, then it is the Employment and Labor Relations Court Act, Employment and Labor Relations Rules.
Let's go to review of judgments by ELRC. What are the provisions for this? What's the legal or statutory backing for this review of judgments by employment and labor relations courts? Nona, which one is it? Section, let's start with the CPA section. Section 80 of the Civil Procedure Act and Order 45. The CPR. Let's just confirm. See Kosawa. Yeah, section 80. And then Order 45. Let's just confirm. Section 80 and Order 45 of the CPR. And Order 45 of the CPR. Yeah, review. So now, since we've identified that's the law, so you see when you're answering these questions, if you bring those things out there in black and white, no, you've bolden in your black pen. If you use a black pen in the exam room, you've written joinder of parties is found under Order 1 of the CPR. Review of judgments is found under Order 45 and Section 80 of the CPA and Order 45 of the CPR. Automatically clicks. The examiner knows this person knows their stuff. Yeah? So the next thing now for you to do is now to go on ahead and analyze joinder of parties. Now, based on these facts, guys, please help assist me comment. What about joinder of parties? Please comment on this. Anyone? Just unmute and then comment.
Okay, so joinder of parties happens where the facts are closely related to each other, or the defendants in question have committed an act where the court would consider are closely linked to each other. It's something about similarity of facts and similarity of circumstances.
True. That's true. What else? On joinder of parties, let's, because it's a discussion. You know, today this is a question, this is the way they've set the question today. Tomorrow they said, so you're revising. Just mention everything to do with joinder of parties.
And similarity of the contract as well.
Similarity of
the contract.
Okay, go on.
On my end, I also know the test joinder. And I know that it must be a necessary party. Must be a proper party. And then the relief must be flowing from the defendant to the plaintiff.
Yeah.
And then in case the presence of joining one of the parties, the way is to enable court effectively adjudicate on the suit. And if one of the party delays the process, it may be removed.
Yeah. Go on. True. Yeah.
Thank you.
You're welcome. Now, who else?
I guess one can also talk about the test, which is whether common questions of law or fact would arise if the suit was brought by different parties.
Yeah. Okay.
I'm also thinking. All right, I don't know whether the issue of compulsory joinder and permissive joinder would come in this context, where compulsory joinder is parties who must be joined to the suit and the court cannot proceed without them, and permissive joinder, I think that those parties, they don't necessarily have to be joined to the suit, so the court is able to proceed with the suit even in their absence. I think that was the definition to the best of my recollection.
That's good. Yeah. Go on. You're saying true, valid points.
Hello.
Yeah.
I don't know whether order 1 rule 9 on misjoinder and not rendering the suit fatal or cannot defeat the suit could be a valid advice.
Misjoinder. Yeah. Misjoinder of parties. No suit shall be defeated by reason of misjoinder. Yeah. So what do they mean? Okay, we'll go back to that. I'll frame the question back. I'll frame the question on misjoinder. But here it is. These are the things to do with the joinder of parties under order 1 of the civil procedure rules. And of importance here is order 1 rule 3 on who may be joined as defendants. What does it say? All persons may be joined as defendants against whom any right to relief in respect of or arising out of the same act or transaction or series of acts or transactions is alleged to exist, whether jointly, severally, or in the alternative, where if separate suits were brought against such persons, any common questions of law or fact would arise. So you all mentioned these things too. All those things here when you're explaining the issue of joinder of parties. Now let's try and relate this thing with the questions. Give a brief on joinder of parties. So you're the legal officer employed by Granto Limited Company. You need to prepare a brief. The former director of the company, Mr. James, is aggrieved by a ruling which the judge declined to review and set aside. In the judgment, the court held that Mr. Peter James, who was not a party to the suit, had sexually harassed Mary Amber. Accordingly, the court awarded her Kenya shillings against Granto Company Limited. Mr. James has appealed the decision of the court to the Court of Appeal, alleging that he was not given an opportunity to be heard. So somebody kindly comment on that. First of all, let's start with the claim. Was there a proper claim against the company in the first place? Was there a proper claim against the company? What do you think?
Hello?
Yeah?
I think in the question we've been told that Mr. Peter was not given an opportunity to be heard.
Yeah.
And from the principle of natural justice, one is audi alteram partem, which states that an accused should be given an opportunity to be heard. And also, Mr. Peter James was not a party to the suit. He was not informed of the suit. Yes.
That's a good observation. What else? What else do you guys think? Okay, let's first begin with the question of how do you bring a suit against a company? A company can, first of all, a company can sue. Go on.
You sue the company itself, or it's actually a legal entity?
You sue the company itself. It's a legal entity, yes?
Yeah.
You sue the company itself. Now, what I will say in this, okay, there were issues that were raised here by by Peter James, that he was not a party to the suit, he wasn't heard and so forth. But let's think of it in this circumstance. Let's pretend this was not an issue of sexual harassment, but it was a road accident case. And it was a road accident case, and it involved a company. In as much as we usually bring in the defendant, we bring in two defendants, so we can bring in the driver and the owner of the motor vehicle, the beneficial owner. So if the beneficial owner is a company, you will have the driver as a defendant, and you will also have the beneficial owner, the company, XX company, as also the defendant in its own name. But at the same time, you can choose not to even go after the driver, but just go after after the company itself, and leave alone the driver. It happens. You can choose who you want to bring a suit against as a plaintiff. So in this circumstance, give a brief on joinder of parties. Now, these guys sued who? These guys sued the company, and based on the principle of vicarious liability, yes, there is a remedy that flows. There's a cause of action that flows from who? Let me just open it. Not even based on joinder of party. Okay, just come here. Okay, now, okay, best, it's not here, but okay. Before you sue, you have to determine certain factors. So does a remedy flow from the company to who? From the company to the person who was sexually harassed? Yes, a remedy flows directly from the company to the person who sexually harassed. But at the same time, in the aspect of what my colleague just talked about right now, it's prudent for you to bring who? Bring Mr. Peter James into the matter as a second defendant. Maybe as a first, whichever way you will put him. So, yes, the issue on joinder of parties, James, together with the company, ought to have been the defendants. They ought to have been joined, because who can be joined? Who can be joined? Let me just read for you the brief here. Who can be joined? The brief section here. Who can be joined? All persons can be joined in as defendants against whom any right to relief. C1, any right to relief. There's a right to relief from the company. There's also a right to relief from Peter James. Yeah? Even if the company was not found culpable, Peter James, you could still go after Peter James, and the court could still the court will still state that this person is liable to compensate you, arising out of the same act or transactions, or a series of acts or transactions as alleged to exist, whether jointly, severally, or in the alternative, where if separate suits were brought against such persons, any common questions of law or fact will arise. So yes, you can bring the suit against the company. You can also bring the suit against James. Common questions of facts will arise. Common questions of law will arise. And based on that, these people ought to have been joined as defendants, so as to completely determine this matter, or put this matter to rest. So when you're commenting on the issue of joinder, you will have to note the rules, what you guys just talked talked about. And these are the rules. 1. Any person against whom a plaintiff claims some relief may be a defendant. That's obvious. However, it's not necessary for each defendant to be interested in all the relief sought or in every course of action. The court may make such order as it appears just to prevent any defendant from being embarrassed. A court can make a defendant merely to obtain costs. There's an issue of costs. Under certain circumstances, a person may be made a defendant for the purpose of discovery. A company that has ceased to be in juristic existence in the country of its incorporation cannot be sued as a defendant. That's pretty obvious. And a person cannot generally be added as a co-defendant against the wishes of a plaintiff. It's just obvious and so forth. So from this question, certain facts arise. There are common questions of law. You have a right. You have a right against Mr. Peter James. You also have a right against the company. Okay? And the proper way in which this suit ought to have been brought will be by bringing these two persons as defendants, because they form, like the facts, they form part of the same transactions, and rights of reliefs directly flow to each person. So take it as I just explained before. If it was a driver, you can bring a suit against the driver. You can bring a suit against the company itself. But now, to properly adjudicate that matter and to properly put that matter to rest, it's prudent for you to have both of them as defendants, so as to settle all the issues, okay, and to have a solid case. You may bring a claim against the company itself in this circumstance, and you actually prove, and then you are like, what happened in this thing? Chances of it being declared null and void by the court, it's going to be, if this thing went to appeal in a real life practical situation, chances of it being overturned below, because the company, even if this person was not given a fair hearing, this is Mr. Peter James, the issue is based on the allegation that, but on the fact that Peter James sexually harassed someone. It's prudent for the company to have brought this person in as a witness. Yeah? By bringing this person in as a witness, he was heard. He gave his testimony, and the court made the relevant decision. This matter could not be conclusively determined if Peter James was not put to the stand. Like, practically speaking, that's what will happen. If this thing was appealed, chances of it being successful in the appeal very low, because this person was given an opportunity to be heard at one point, either through his testimony, either through being one of the witnesses, or either through it being adjudicated and so on, and all those issues revolving around it. But since the question is saying on joinder of parties, it's prudent to note, just list order 1, rule 3. Talk about who may be joined as parties. After you've talked about who may be joined as parties, talk about the fact that there's a right of relief flowing from you, from the plaintiff, towards who? Mr. Peter James. There's a right of relief flowing from that towards the company. Because of what? There's the issue of vicarious liability, and there's the issue of, there's a wrong that was done against you, so you sue the company, and all those issues on parties to a suit. After you've talked about that, now talk about the issue of conclusively determining the suit. The issue why we join these people together is so that we don't have numerous suits. Yeah, we don't have numerous suits on the same issue. Well, we can have one suit, and all these things are determined in one suit. So instead of having two suits against Peter and also against the company, just bring them together for it to be determined. And practically speaking, for those who do litigation, there are circumstances where you will find there are various suits against a defender, and the court orders later on for these matters to be consolidated and be heard at once. Yeah? And it happens. So that's how we would approach the question when we talk about joinder of parties. Bring all those issues, order 1, rule 3, rights of reliefs, the issue of conclusively determining this matter by having Mr. Peter James as a defendant, and the prayers that will revolve there will be jointly and severally. That this person and this court find the defendants jointly and severally liable for, and we're done with that. Yeah. That's how it is.
Short question. In this instance, since the question does not expressly say that Peter James is I guess the person who committed the sexual assault,
yeah,
what claim would we have against him specifically so that he would merit to be a party? I think I've not made that connection.
Kindly, okay, the question is not saying that this person?
From my reading of the question,
yes,
we are just told that Peter James is the director. Yeah, we have not been
yes.
told that he's the one who did the sexual harassment. So I'm not seeing our case against him specifically, or a suit against him specifically. So that's what I'm trying to find out.
Oh, yeah, but they've said in the judgment, the court held that Mr. Peter James, who was not a party, had sexually harassed. So the court found him liable, even if he wasn't a party.
Oh, fair. My apologies.
Yes. So the court finds that, this person is liable. The court found that this person is liable. So there was a right of relief towards Peter James and also towards the company on the aspect of vicarious liability.
Yeah, thank you.
Another clarification, Solonka.
Yes,
under the Employment Act number 11 of 2007, Section 6, it says that sexual harassment may be imputed either from the employer or a representative of the employer. So when we are looking at it from the perspective of a representative of the employer, then are we talking about vicarious liability? And so it is not factual that Mr. Peter was not included if we are looking at it from the aspect of agency at Section 6, because they are talking about the representative of that particular employer. Now, Mr. Peter being a director here, it means that he's a representative.
That's true.
Secondly, as you comment on that, I wish you would also comment, because now we are doing a brief and there is a whole 10 marks on Order 1 Rule 10 on substitution and addition of parties. Whether now we would advise that in case there is a review or in case there is a new trial, the issue of addition of parties would come in. Those are my two concerns. Thank you.
You're welcome. So on the first aspect of the company, that's very brilliant, because I hadn't even known about that Section 6 on the aspect of agency. It's very brilliant. It shows that you go read the law. That's true. You can sue the company. And actually, as I reiterated before, this suit was brought against the company, and this thing revolved around Peter James. Peter James cannot say that he wasn't heard by virtue of the fact that he is at the center of the dispute. There is a way he was brought into that suit, either as a witness or in any other manner. So there's a way he was heard. So that's what I was saying, in terms of it succeeding in an appeal, real life practical situation, very, very minimal, extremely minimal. Yeah? That's a very good observation. Now, on the other aspect of addition and substitution of parties, let's actually just read it, Order 1 Rule 10. So where a suit has been instituted in the name of the wrong person, of persons as plaintiff, or where it is doubtful whether it has been instituted in the name of the right plaintiff, etc. So the court may at any stage of the proceedings, I'm just skipping, but it's projected on my screen so you can see. The court may at any stage, either upon or without the application of either party, and on such terms as may appear to the court to be just, order that the name of any party improperly joined, whether as plaintiff or defendant, be struck out, and the name of any other person ought to have been joined, whether as plaintiff or defendant, so forth. So basically, anyhow, where a defendant is added to substitute the plaintiff unless the court otherwise directs, be amended in such manner as may be necessary, and amended copies of the summons, so forth to be done. So, substitution and addition of parties. From the wording, Order 1 Rule 10, when do you bring it? Where a suit has been, so there has to be a pending suit. So what's a pending suit? A pending suit is a suit that has been instituted and a suit that is yet to be determined and heard. During that bit, you can make an application at any stage of the proceedings for either a party to be added, a party to be removed, or a party to be substituted. Yes, you can bring that application. In this circumstance, a judgment was already rendered. The only instance where you will now talk about adding or substituting this party will be, let's say this thing was reviewed, and after it was reviewed, the court issued for fresh trial. That's where now, when the trial now begins afresh, you can now bring issues to do with, maybe amending, adding that party, and so forth. That's when it would arise. But once a judgment has been delivered against the company, how will the party now? You cannot add a party or substitute a party after judgment has been delivered. What are they coming there to do for? The court has already determined the rights and liabilities of every party there. So why are we bringing another party? Yeah. So unless a fresh trial has been instituted, so maybe the matter has been appealed and this person was successful, and the court set aside and ordered for a fresh trial. If it was a fresh trial, then now maybe you can bring for the matter to be heard afresh. Then now you can bring that that aspect of adding or substituting that party. Okay. And then now, since we're talking about that, there's also the aspect of that party notices. When do you bring an application for that party? Since you're revising.
You bring an application for that party, for example, the plaintiff has sued the defendant, and there's another party who is not a party to the suit, and the defendant is claiming or blaming that person for either contribution or indemnity. So they issue that party notice so that they can bring that person to be a party to the suit, since they were not a party in the first instance.
Brilliant. That's brilliant. Now, in addition to that, maybe you could now comment. At what stage do you bring this? Can you bring this thing after the defense? Okay, let's say the plaintiff, there are stages of the plaintiff has closed their case. Then you realize, hapa sasa, I need to bring another person here. Can you bring here that stage? Maybe can you bring it at the execution stage? Can you bring it like during the submission stage? At what point do you bring that party claim or you bring that application?
After pleading.
Yes?
Before
after
pleading.
the pleading.
It's somewhere in
After.
between.
After or before?
After the close of pleading.
Within how many days?
14.
Yeah. Yes, within 14 days after the close of pleadings. It goes back to the question. Let's define when do we have close of pleadings? When are pleadings deemed closed?
Order 213.
They close after the last thing is filed.
After the last thing is filed, the last thing maybe maybe the defense, maybe the reply to defense. Yeah, that's guys are ready for this paper. So yes,
what they say is that the pleadings will normally close 14 days when maybe the defense has been filed, and where maybe there's a counterclaim, a response to counterclaim, or in this case going to be a defense to that counterclaim.
Yes.
Yes, I think that is actually the wording of
Order 213. That's true. Yeah. So the last document that is filed, the last document may be a reply to defense or a defense to counterclaim. What the wording is there under Order 213. So that's it with regards to addition and substitution of parties and also that party notices. It's a good thing if it may come in the exams. The applications, maybe. Addition and substitution of parties, which is the application that we'll draft. Let's say they told you to add a party. It's a question that people bring. It's a question that is brought in the exams. If they say, or if the facts point you towards an application for addition or substitution, which application do you bring in court?
Chamber summons.
Chamber summons. That party notice?
Chamber summons.
Third party application?
Chamber summons supported by an affidavit.
Okay. Now, since you guys don't even unmute, don't even mute. Summary judgment.
Notice of motion.
A notice of motion.
Okay. Let's injunction.
Notice of motion.
Security for
Notice
cause.
of motion.
Notice of motion.
NM, notice of motion.
Notice of motion. You guys are sharp. I don't even have any other. You're good. You're good to go. Review. What is the application for review?
Notice of motion.
Notice of motion. Revision.
Notice of motion as well.
Notice of motion.
Motion.
Okay. Sawa. These are
Yes,
cooked.
Miss Lonka.
Yes.
Speaking of, I've got a question. When you're applying for, let's say an adult person is applying under Order 32 to be a guardian ad litem minor, what application do you use? Because it appears that two approaches rather contradicting. Because Ms. Mongare says it should be notice of motion or petition, whereas Herbert says it would be chamber summons. So I'm not very certain. Perhaps you could give guidance.
Okay. Now, suits by or against minors or persons of unsound mind. Okay, let me just have a cursory look at it. Let me look at the rules. Who may act, representation of minor. Okay, if you can check Order 32 Rule 12. That Rule 12 sub rule 5. Any application under this rule may be made ex parte by chamber summons, but no order discharging a next friend or permitting. So procedure for where a minor attains majority. So specifically under Order 32 Rule 12, the application will be a chamber summons. Now, let's go to these applications for rules. So is there any place under Order 32 where they're talking about chamber summons?
No, apart from where attains. The others, they don't speak of the application.
If I may contribute, when you look at the order that speaks about enjoining third parties, it talks about, it goes on to say something along the lines of people of unsound minds, minors. You cannot enjoin them without like having a guardian. So maybe that's why people talk about as we are finishing. Yeah.
That's true. That's why I was even opening Order 1. Because I've read something on it under Order 1. That's what I'm looking for. Is it Order 1 rule what?
It's the same place we were looking at in relation to third parties.
15.
Order 1 rule 15 here. Rule 15 sub rule. Kindly point it out to me. We can see there's something on Order 1. Can't remember the specific rule. Rule 15. Where is it?
Rule 2 sub rule.
Sub rule. Maybe somebody can check as I check something else here.
I suppose it should be Order. Rule 10, Rule 3.
Order? Sorry, order? kindly repeat. Let's see sound.
Okay. I'm not certain whether this is what the last speaker was talking about.
Just go on. It's fine.
Order 1, Rule 10, Sub Rule 3.
Order 1, Rule 10, Sub Rule 3. Let me just open it. Okay, yeah. No person shall be added as a plaintiff suing without a next friend or as the next friend of a plaintiff under any disability without his consent in writing. There too. Now, on this question, I will tend to say,
Solongo,
who's,
can you hear me?
That's Lavins. Okay, Lavins, go on.
I'd like to just put this matter to rest. Yeah?
Go on.
So the suits by minors and persons of unsound mind. The rule of the third is all applications under this particular order will be through a notice of motion. So reliance most of the time shall be placed on Order 51 as the manner of application is not actually prescribed, right? So I will agree with Mungari what she did say. So this, because the manner upon which the application is actually supposed to be made is not prescribed. So you go by notice of motion. And then there's the other side of it, suits by a minor perhaps not attaining, a minor on rather attaining the majority age. So these are the Rule 12, Sub Rule 5 of the CPR, and the mode of application will be through chamber summons. So this is not provided in the rules. So I think with that, I'll put that matter to rest.
Actually, that's true. That's what I was actually going to say. I would also side with Mrs. Mongari. Because, at the same time, rules are rules. The default application is a notice of motion. If under Order 32, it hasn't talked about, that's why I was very keen to go look in particular, as it provided for. And they haven't provided for chamber summons. The only place they provided for chamber summons is under Order 32, Rule 12. So, based on that, I will also side with Mrs. Mongari on that. Unless I haven't read the entire order word for word, unless inside there's a provision talking about chamber summons application. If there is none, then I will go with Mrs. Mongari. And nowadays it's a safe bet in court. If you're not sure about how to bring, okay, it's something that I don't prescribe. It's good that you read fast before going. But people say if you don't know how you should draft a document, just go through by way of a notice of motion.
Plus,
yeah.
We also have this doctrine of constitutional avoidance. If you're able to avoid using any petition, just go through the notice of motion.
Yeah. Thank you so much. Thank you so much. Now,
Solongo, just a moment, before you proceed.
Yeah.
At this point in time, folks, you have no more time left to go through the entire CPR. So at this point in time, there are things that you should be having on your fingertips. And how do you approach the court? If the suit itself is by purpose, how would you approach the court? And whether also the suit is against trustees, executors, and administrators, how would you approach the court? Also, suits by or even against the firms or other persons carrying out business in names other than their own. Like the things at this particular point in time, you shouldn't even be referring to the CPR. You should be perhaps making them sound an alarm in your mind, that perhaps you need to do more if you don't have them on your fingertips. If I were to ask you what mode of application would you perhaps use in proceedings by or against the government? Why would we use an application for certificate under Order 21 Rule 3? You should tell me why. what mode of application would we perhaps use in commission references, and why do we apply for commission under Rule 4? Why would you pay into the court and tender evidence for the same? You understand? So civil procedure rules is about, it's the backbone of the civil litigation. And there are things that perhaps you may not have time to go through an entire civil procedure rules, that's fine. But there are things that CLE may never fail to test. And those are the things that you should perhaps take cognizance of, and you should focus your energy on those particular things. There is a document I will send you after this. Go through that document each and every morning. It's a 13-page document, but it has everything you need to know about the civil procedure rules, what mode of application, and why will you choose this mode of application, and not, why will you choose notice of motion in North Chamber summons and the other way around. So it's a summary, perhaps, I'd say, of the civil procedure rules, and it's exactly what I did use in my civil litigation. I was revising at this particular point, and I did know that I only have, a fortnight to go, because I wouldn't go through my notes at this particular moment. I would go through perhaps things that, I just used to see, on my folders in my laptop, reportedly. So go through this particular document. It's a 13-page document. You read a page a day for the next 13 days. And best believe, because civil litigation is the first paper. So on the 13th day from today, you'll be good to go. And that's the essence of civil litigation. Drafting, you do the drafting, time yourself in drafting, and you can focus on the rest. So yeah, I'll send the document anytime from now. Talk to you, Salonka.
Thank you so much. Thank you so much, Lavin, for that. Thank you so much. So yeah, that's it. That's it now with the agenda. But now you've not answered the second bit of the question on reviews. But review of judges. Yes?
Can I just say something maybe before we proceed? Because
yeah, go on.
There's something that I've seen about the Guardian when it comes to maybe someone who has gone insane. And I seem to see that he's saying now for these applications for Guardian, where maybe a child is concerned, that the court with the requisite jurisdiction is maybe the magistrate court. But looking at the Mental Health Act, I seem to see that the court with the jurisdiction, it comes to someone who has gone maybe insane. And let's say that this person was maybe the plaintiff, then you need to maybe substitute this person, that then you have to move the High Court for the same. And then you, once you've gotten the order, the guardian ad litem itself, then you move now to the court where the matter has been instituted, and then now you can do the substitution. So maybe that is something I just need to point out.
Thank you so much. It's a learning process, really learning a lot. Thank you for that. Now, we go to review. Review, we've mentioned it's under order section 80 and under order 45. Hatutakaa hapa sana. So, under section 80 of the Civil Procedure Act, what does it say? Any person who considers himself aggrieved by a decree or order from which an application is allowed, but which no appeal has been preferred. That's the first thing you need to check. From which an appeal, you are allowed to appeal, but from which no appeal has been preferred. Or by a decree or order from which no appeal is allowed by this court, may apply for a review of the judgment to the court which passed the decree and made the order, and the court may make such orders thereon as it thinks fit. I've read for you section 80. So based on this, does this person have a chance of success when it comes to review? Does he have a chance of success when it comes to review? Will his review be successful? Or rather, let me put it this way. If you appeal a matter, can you review it?
There are some those circumstances. Once you do the review, you cannot do an appeal. But then there are those exception circumstances where if you do a review, the court will allow you to do an appeal. But once, I think, if I may put it, that once you do a review, the law states that you cannot do an appeal.
And once
apart
you choose
from
an appeal.
Yes.
Yes. Now, yeah. So under this circumstance, it says, if you're aggrieved, from which an appeal, you're allowed to appeal, yes, but you have not preferred appeal. Here, from which no appeal is allowed. So in this circumstance, this person, the court held that Peter James was not a party to a suit. He has appealed the decision to the Court of Appeal. And then now he wants the matter to be reviewed, review of judgments by the ELRC. So the chances of success in that circumstances, it's low. And then also, other than that, there are subsequent bars. Now the subsequent bars are here. You bring an application for review where you've discovered new evidence, and this evidence could not be reasonably, could not be accessed at the trial stage or, when the matter was being heard or during the pendency of the suit. You've discovered them late, but after exercising all due diligence, you could not have gotten this evidence or this new facts at the time in which this matter was being heard. Yeah? That's when you now bring an application for review. In this circumstance here, or the facts that you've been given here, I cannot see any evidence that was not available. If this person saw that he was not going to be okay, he should have presented himself initially. Yeah? So bringing an application for review will be clutching on straws. It wouldn't work. The chances of success are very low. Because if you comment about reviews, you talk about section 80 section, we've mentioned the aspect of when you bring an application for review and the circumstance, new facts, new evidence that was not reasonably available during the pendency of the suit or could not be gotten even after exercising due diligence. So that's question 2. I think in brief that.
If you allow me, please.
Yeah, please go on.
I feel you're focusing only on the CPR, but there's an express provision for review under the Employment and Labor Relations Court rules, particularly Rule 33. Apart from the 2 grounds you've mentioned, there are 2 additional ones. That is, if the judgment or ruling requires clarification or for any other sufficient cause. So if Mr. Peter James can show sufficient cause, won't that give him an opportunity to apply for review? I'm not saying that it's feasible, considering he has already appealed, but I feel we shouldn't disregard this provision and include these other 2 additional grounds. That is Rule 33 of the Employment and Labor Relations Court. The rules, that is Rule 33 of the 2014 rules, if I'm not wrong. Yeah, 2014 rules. That is legal notice number 146.
Let me just look at it. Okay, what I'm doing here, kindly, I highly discourage people doing this, but I'm just doing it for the interest of time. Never Google statutes. Let's look at it. Oh, that's the Employment Act. Sorry. Okay, under which subsidiary legislation is it found under?
Solonka, it's the Rule 2016. It's under the Employment and Labor Relations Court Act.
Employment and Labor Relations Court. Actually opened it. I cannot see it under. I opened it, but the subsidiary legislation bit is usually here, but I can't find it here.
Yeah, you search ELRC 2016, ELRC Rules 2016.
ELRC Rules 2016.
Yeah, they detached it, I think, from the main act for some reason.
Okay, ELRC Rules 2016. Let me just open it.
This one written 2011. The one written number 20 of 2011. The third search term. Yeah, the third search term in your results.
Okay. Thank you for that. Thank you. Let me now open it. Now, there are two main reasons why I left out this thing, why I didn't even go into the Employment and Labor Relations Court rules. Okay, the main reason is based on the fact that in an exam setting, yes, today they may bring an issue to do with the ELRC, but tomorrow they may bring ELC. Yeah? So in an exam setting, the chances, there are people who will have read this thing and have remembered, but chances of you, okay, let me ask, have you guys read on reviews for small claims court, like for all the laws, like all the courts in the country, even the Court of Appeal and the Supreme Court? Have you read that, like exhausted everything on reviews? You've even checked what this thing called the sleep rule. You've checked the sleep rule, COA, the Court of Appeal, the Supreme Court, and so forth. Have you checked? So the reason why I left it, it's because I presume that the knowledge of CPR together with the knowledge of the CPA, that would be enough to gain you marks. But now to impress the lecturers further, if you mention this thing, I assure you will have impressed them. That's a guaranteed point. Huh? So in this circumstance, they're saying a person who is aggrieved by a decree where an appeal has been but not preferred, if there is new, that one is in the CPA. There's an error apparent, that one is in the CPA. If the judgment or ruling, that one is in the CPA, or for any other sufficient reason. Now, for any other sufficient reason, it depends. It depends with how you argue it. Depends with how you argue it. You may argue it, win. You may argue it, not win. So for any other sufficient reason, that's really broad enough. It opens you to, I'll call it litigation imagination. Craft your orders very well, craft your court documents very well, and go argue before the judge. So yeah, depends with how you argue. But if you could mention that Rule 33, you will have really, really impressed. You may gain an extra mark for that. So yeah, that's a good one. Thank you for pointing me out to that.
While you're still on it, which is a very good point that has been raised by the former speakers.
Yes.
The Employment and Labor Relation Court is of the same hierarchy or level as the High Court. And that the CPR, the Civil Procedure Rules, they are expressly for magistrate courts. But again, the Environment and Land Court has expressly put a provision that the Civil Procedure Rules are applicable. But we have now rules for the Employment and Labor Relations Court Act. Is it in order when we have such rules to still refer to the CPR? Thank you.
Okay. If you have the rules like for the ELRC and if you have the rules for the ELRC and what? And now, if you have the ELRC rules, is it prudent for you to go to the civil procedure rules?
Yeah, is it okay?
Okay, let's just look at it here to Maramoza, you'll find it. Yeah, it's okay. Mentioned. So you see what happens is now you will find there are certain courts or tribunals that provide for exclusion of the CPR. Not exclusion per se, but what they say is there's a statement or there's a section saying that in the absence of any rules on a particular procedure, parties may resort to what? The CPR. So what they're basically saying is you first approach the court using the rules for that forum. If there's any if there is any contradiction on that, or if they're not contradiction, sorry, there is an absence of a provision, then you can go to the CPR. So it depends. So for this one, you can see there are circumstances where they're saying rules on execution of an order or decree shall be enforceable in accordance with the civil procedure rules. A person who wishes to institute judicial review shall do so pursuant to that under the Law Reform Act. Those are two provisions. And then also you need to check, let's open this thing. An act of parliament to be applicability. Where is this thing? The objective. Okay. The act applies to proceedings in the High Court and subject to the Magistrates Courts Act to proceedings in subordinate courts. Let's look at the CPR. Okay, in summary, it totally depends with the rules. So you will first go check, for instance, if it's the Employment and Labor Relations Court rules. Check the rules. If it doesn't provide for you to resort to the CPR, it can't. But in this circumstance, it doesn't. So where there is lack of a provision in the rules, you can resort to the civil procedure rules. But at the same time, I've been in court where there's somebody in the Court of Appeals recently, somebody raised a particular point, and he was actually arguing to the effect that the civil procedure rules doesn't apply in the employment and labor relations courts matters. And the magistrate told him to, not the magistrate, the learned judges, the Court of Appeal, the 3-judge bench, they told the person, okay, now, what you can, please, do you have any case laws to support or to support your arguments in that? They didn't have any case law to that. So I think it's a relatively, it's an area that can be argued for. Personally, I think you can use the CPR in the absence of any rules, unless the rules themselves provide for the contrary. That's how I would argue.
Thank you so much for the data.
Okay, you're welcome. Hi. Now I think we're done with that number 2. We spent time on number 2, but let's go on to number 3 now. Somebody read number 3. Anyone can read number 3?
Juma Jomo of P.O. Box 1314 Kericho has approached you with the following complaint. That in 1987, he was enlisted in the Kenya Army as member number 59030 and posted to the Military Corps Lanet Department. He rendered service with declaration and rose through the ranks to the position of senior sergeant, earning a salary of 59,884 Kenya shillings. In the month of July 2017, he was charged with the offense of neglect of duty and 2 counts of conduct to prejudice of good order and discipline contrary to Section 65 and 121 of the Kenya Defence Forces Act, respectively. He was arrested on 5th August 2017 and confined in the barracks up to 9th September 2017 when his trial commenced. He was not allowed to instruct anybody to represent him. He was actually found guilty as charged and was summarily dismissed from the force without any benefit. His dismissal was not subjected to the automatic administrative review provided by Section 159 of the Act. Juma contends that his right to fair labor practices, fair administrative action, and to a fair hearing have been violated. He has also taken issue with Section 244(2) of the Act, which provides for the withholding, reduction of the amount or suspension of benefits payable to any member who has been dismissed under any circumstances. The service commander, Kenya Army of P.O. Box 3178, Nairobi, did not respond to his request for automatic review. He has requested you to study the pleadings, seeking redress for the alleged violation of his rights. Draft appropriate pleadings indicating the nature or reliefs you will be seeking.
Hi, now let's go on to that. What do you think the answer is? Or how would you approach that question? How would you guys go about that question?
Hi, Sam.
Yes, hi, how are you doing?
I'm fine. Mostly from the facts of the case, there are elements of the rights of the person because they are being infringed, especially the elements of fair administrative action as per Article 47 and Article 50 on the issue of fair hearing. So basically, I've drafted a petition in regards to seeking the rights and also in the act, since there's an issue of an interpretation as per the jurisdiction of the High Court based on Article 165. So I'll have used those that I'm subject to guidance.
Yeah, that's that's a good one. Yes. Anyone else? Contrary view, similar view, contribution, addition?
Brian.
Yes.
How are you doing?
I'm well. How about you?
I'm in Kofiti, bro. So my view, just right off the bat, I can see this is just judicial review. A reasoning as to why I'm saying it's judicial review. As much as this guy Juma Jomo has committed an offense under the military corps, he ought to be accorded the right to fair hearing, and by failure of the KDF, or the failure of the KDF or the commander to accord him his right, his constitutional right of a fair hearing under Article 50, it means it's a breach of his rights. So I agree to some extent with Kitau, but now the key thing here that the key distinction here is this statement: his dismissal was not subjected to automatic administrative review provided for by Article 159 of the Act. I don't know which Act that is. The KDF Act. So now the fact he was dismissed and procedurally, that is an action by an administrative body, a quasi-judicial body, because I believe the commander or the military corps, it has some sort of quasi-judicial authority. It's like how you say the registrar of titles can revoke a title. You get? So that's why I would go with the route of judicial review, but bearing in mind 10 marks, also time and whatever, pressure exam, I would just write a petition, but I would be seeking the 3 orders plus compensation under Article 22 ama ni article gani yenye inasema we seek compensation. So among those 3 orders, certiorari, mandamus, prohibition, pia ningepeza na compensation.
Okay, nice. So we mentioned what's happening here. We've mentioned the orders. Let's see. Let me list the judicial review orders we mentioned. Certiorari. In the meantime, anybody else contribute? Floor is open. Mandamus.
Yes, I would like to contribute based on what the previous speaker has said. So I have a contrary opinion because I hear him on the aspect of judicial review, but okay, I can see you have already typed some of the thoughts in the chat. Is it the chat or what? The note. What orders will you be seeking? So we are told Juma contends that his right to fair labor practices, fair administrative action, and to a fair hearing have been violated. So we have like a plethora violation of rights like that. And then we are told he has requested you to study the pleading, seeking redress for the alleged violation of his rights. So if you look at that and we compare a petition versus judicial review, both of them would be right in that sense, but which one will assist you to act upon the instructions of your client? So a petition in that sense would be able to address the violation of rights. If you look at, what are they called? The Mutunga rules. Any person who is claiming a violation of rights in that way. If you look at Article, something like that. And then under Article 23 of the Constitution, the remedies that a court can give in a petition, they include judicial review. So in that sense, the petition gives you substantive remedies. You could get compensation, you could get judicial review, and you could as well get a declaration of rights. On the other hand, in judicial review in that sense will be limiting because it only looks at the decision-making process. It will not address the merits of the case. So in that way, you're only limited to saying that the decision was improper or irrational. And that will be the end of it. But if you look at the question, have you answered it? Have you helped your client seek redress for the alleged violation of his rights? So a petition vis-a-vis judicial review, in that sense, a petition helps you answer the question and also gives you substantive remedies, and you could even get that judicial review that you're talking about. So at the end of the day, the orders that you'll be seeking will help you determine which pleading you should draft.
That's absolutely, like, you've summarized the entire thing perfectly and well. Like, that's brilliant. All of you have analyzed the question perfectly. All of you have analyzed the question legally, and I'm actually impressed with that. So you've mentioned everything there. So what orders will you be seeking? You want to quash first of all. Yeah. What's the question? What are you quashing here? Let's be step by step. What are you quashing here? The summary dismissal. Yeah. Cindy. Yes. You guys are following.
Yeah, we're
Yes.
following.
What are we going to look for, or what are we trying to enforce with the order of mandamus?
Reinstatement.
Reinstatement, absolutely correct. Now, what are we prohibiting? Hey, I've already prohibition instead of prohibition. There's external factors causing that. Prohibition instead of prohibition. Yeah. So, what are we looking for when it comes to prohibition?
As long as ingesema that service commander be prohibited from dismissing the nani, that Uyu Jumajomo, I don't know, he's a corporal or whatever he is. Yeah, just the service commander be prohibited from summarily dismissing him. Yeah, that's what I would say.
Yeah, there's a way you can craft it. There's a way you can craft it.
There's a way you can craft it, but not in an exam situation, or your mind is on overdrive, so so yeah.
That's true. It's true. And also, you can prohibit further withholding, reduction of any benefits from him. Yeah, that's how you can craft all those things. Declaration of rights. Maybe there's one order here. I don't know if I'm overstretching it, but you could advise me. He's saying that he's taking issue with section 244(2) of that act. So, can you seek against that? Yeah, it is. Yeah, we could maybe, I don't know if you can advise me, but I will also add another order other than the ones that you've mentioned. a declaration of invalidity of that particular section of the law. I will. Yes.
It's in order for that. It's one of the instructions the client is asking. So may I think it's right. It's one of the instructions the client has given us.
Yes.
So yes. So you should apply it.
Yeah, you should put it there. Yeah. So and then that declaration, and you have your fallbacks. Now this is a petition. You're supposed to draft a petition in this circumstance. Huh? It's a petition. You guys know how to draft a petition, the format for drafting a petition. Are you familiar with it?
Take us through.
Okay, it's easy to forms, but according to the Mutunga rules, so you're familiar with the.
Yes. It's actually in the schedule, the first Form 1.
Yeah. So in the Mutunga rules, there's a format. Yeah. So let me just I'll compare that together with the notes. Let me not go to the notes first of all. Let's just begin with this. So these are Mutunga rules. Whenever you're drafting any petition, there are certain things that you need to clearly lay out. Yeah? This is it. So any application, basically what they're saying is any petition as set out in the form in the schedule with such alterations may be necessary. You should disclose the following things: the petitioner's name and address, the facts relied upon, the constitutional provision violated, the nature of injury caused, details regarding the petition, reliefs. Those are the details that you need to do. But here it is. Yeah. So this is the form for the petition. The things that I was talking about, those will be like some small subheadings or subtitles. I'll show you how they come in. Huh? So here, the facts of the case, the nature of the injury caused or likely to be caused, details regarding any civil, criminal, so forth. Those are just like two subheadings. And then now for you just fill in the spaces. So here, the petition of ... the Republic of Kenya address the following. Then the facts of the case, put in the facts. Nature of injury caused, put in the injury. Details regarding any nexus, put in the details there, and then put on your prayers, the one that we've stated, the exact order that is being sought, and you're home and dry. Now, the petition I have with me here is not a petition for violation of rights. It was an election petition, but the format, it's more or less the same. This one is guided by the election. They are the rules, the Supreme Court election rules on how you bring the petitions. But the format is more or less the same. So if you want to have like tidy work or some clean work, these are the ones, this is the notes that I relied on, and basically it's okay. So just do some necessary modifications. It's not the one that has been provided for under the Mutunga rules, but with the necessary modifications, it looks somehow like this. So this is a petition. You have to start by the humble petition of whose address of service is this. Describe the parties over there. Okay, you skip that one, doesn't apply to the Mutunga rules. And also doesn't apply. But are you seeing the way they've set the headings? That's now what I was talking about in relation to this. Now you will have the facts, the nature of the injury, details regarding any civil, criminal, or other litigation. Now, for the format, I don't know about Mrs. Mongare's class, but I know Harvard usually sends people these templates or these pleadings. So you could borrow from guys who are in Harvard's class for him to, for you to see how it looks practically speaking. But the form is basically as it's set out in this form with the necessary modifications. Now, to make your work a bit more neat, you can just organize it in this manner. Issues for determination, the relief sought in the petition, and you're home and dry. And then you support it to the supporting affidavit. Is that clear? I've not done a petition for violation of human rights. That's why I don't have the most appropriate pleading for you guys, but I hope that clarifies it. It's in the rules. And also, I've opened the notes to show you how to at least arrange your work. The most important bits, know where to file this matter. Where will it be filed? magistrates or High Court or the Court of Appeal or the Supreme Court? Where will this petition be filed?
At the High Court.
Yes, in the High Court. The High Court, yeah. Now, nowhere to file High Court. Begin with the humble petition of this and this, then put the headings as has been put under the Mutunga rules. So you have to put, like, there has to be a heading, constitutional provision violated, or maybe the constitutional provision violated. See, you guys remember the Anarita Karimi Njeru principles, pleading to a reasonable degree of precision. So you have to lay down the violations to a reasonable degree of precision. Those are the rules. So those are some of the things that they will be looking for when they are marking your paper.
Loka.
Yes?
Is this the High Court or the other High Court, the one for employment? Employment and Labor Relations Court. Which High Court?
Okay, that's a very good question. Fair labor practices. Let's look at the ELRC. I think I will go for the ELRC. The reason for that is the one that deals with employment and labor issues. But at the same time, I don't know, you guys study acts. Is there any provision in the KDF Act that allows you going from, or in the Employment Act or, the Employment and Labor Relations Courts Act that allows you from going to the...
Solonka, you see, when it comes to military law, you do not, it cannot really be deemed as an employment violation by the employer, quote unquote, the service commander or the platoon commander or whatever, or maybe the general. So in that instance, I don't think you'd go to the ELRC. I had thought about that, but then I realized that you can't do that. So I think you just stick to the High Court JR Division. Yes, High Court of Kenya, JR Division. That's what I think.
Yeah, because something also points me out to that. Huh?
Yeah, you can't sue your employer ati unasue ati komanda wangu wa Lanet ama wa Langata ama hapa ni wapi hapa Thika Road. You can't. Yeah, you can't.
That's something I'll have to do research on that, because as it stands now, I'll have to read the issues to do with military, how their disputes are solved, any recourse mechanisms, or maybe they usually have court martials. How do you appeal from a decision of a court martial, or if there is any? Are you allowed to appeal in the first place?
Solonka, the KDF Act under Section 186 talks about appeals to the High Court when you're appealing from decisions of the court martial. So yeah, there's a direct provision that you go directly to the High Court.
Yeah, and something told me, what appeals. Let's see, High Court.
That's directly to the, because under Rule 7.
Where is it?
Rule 7 of the ELRC rules provides that a petition in accordance with the Constitution of Kenya, protection of rights and fundamental freedoms, and enforcement of the Constitution, practice and procedure rules 2013. Basically, the Mutunga rules would allow you to approach the court through a petition.
A petition. Now the High Court is okay. That's nice. Actually, based on this reading here, appeals from court martial. You see what it's saying? Appeals to the High Court. So they're saying it's to the High Court. If a person has been convicted by a court martial, the person convicted may appeal to the High Court, and subsequent appeals to any other against the conviction may appeal to the High Court. If a person has been acquitted of a charge by a court martial, so here they're providing for the High Court, and I can see this thing is you can see it's fairly recent. Kenya Defence Forces Amendment Act, yeah? It's 2016. When is the date that the ELRC came into place? 2011. So this amendment that was brought in was in 2016, 5 years after the Employment and Labor Relations Court Act was enacted. So the drafters, this is now, if you go to court and somebody raises a PO that you've gone to the High Court instead of the ELRC, this is how you will argue, intention and maybe the purpose of the enactment, if they had intended for it to be the ELRC or something of the sort, they would have brought here and said, if a person appeals, you can go to the to the ELRC. They would have mentioned here the ELRC, the Employment and Labor Relations Court, but they've gone to the High Court. So I think the safest bet will be going to the High Court. Let me contradistinguish that one with maybe another statute to see the wording of these appeals provisions. Environmental management.
Solonka.
Yeah.
So as you look for that, I have a question. How do you differentiate when to do a petition or a statement of claim? Seeing as okay, yeah, we are ruling out the ELRC here because it's military issues, but how would you distinguish between the two?
Okay, sawa. Now before I go to that, guys, can you see how the MCA Act has talked about appeals? Yeah. Can you see here? Now, this is an appeal from the National Environmental Tribunal. It's direct. It's saying appeal to the Environmental and Land Court Act. Are you seeing how direct it is? Meaning, any recourse you have from NET, you don't go to the High Court. You go straight to the ELC. Now, contradistinguish that one with the Kenya Defence Forces Act, which says under that section, it's saying appeals to the High Court. So based on this, I'm not saying my answer is correct, but based on this, I'm saying evidence points towards appealing to the High Court. Okay, not appealing, but in that circumstance, the petition will also go to the High Court since these are military issues. Here, they don't provide for the ELRC or any circumstance to the ELRC. Now, going to the previous speaker, you're asking how you will contradistinguish between going to the High Court and going to the ELRC. Yes, that was the question. Huh? The previous speaker. Right. What was the question was how do you distinguish between drafting a petition and a statement of claims?
A petition and when
sorry, I didn't get you well. Or if somebody got her well, maybe you can repeat the question to me.
So long, I think she's asking.
Yeah.
On a general, question, just put this aside, this particular question. But suppose you're given facts, are sort of similar to these ones, except that perhaps it's not about the KDF. So how do you distinguish whether to use a petition or a statement of claim, seeing as the rule, is it rule, I think 13 or 7, around there, I'm not very certain, of those rules, LRC rules, they say you can do a JR or a constitutional petition, but a statement of claim combines the both of them and it's simpler. So basically, if you use a statement of claim, you'll also be allowed to seek for the remedies that usually seek under constitutional petition and also the JR rates. So how do you determine, are you doing a petition or a statement of claim in terms of where there are constitutional rights involved and at the same time employment issues?
That's a very good question. Now, from what you've said there are rules in the ELRC that talks about doing a statement of claim, like in the form. Okay, I know, and any claim brought in the ELRC
I think
is
that
through.
is rule 4. Rule 4.
Section 4.
I don't know what happened to back.
What she's saying is in Rule 4, and then the other provisions for the petition and the judicial review are in Rule 7. So just check Rule 4 and 7.
Yeah, it is. It so many times. Okay, rule 4. The name. Now, between those two claim or how to use let me open it. The jurisdiction of this court. Two issues that we're talking about. Now, constitutional issue of violation of a right. We read together with. Can you guys hear me? It's network quality on mine. Can you hear me?
You seem to be breaking. You're breaking.
How about now? Can you hear me very well now?
Yeah, you better now. Better now.
Yeah, okay. Higher. Now. Okay. Now, the reason why you will bring well, you will do petition for anything touching on Bill of Rights, anything touching on constitutional violation of rights provisions is by virtue of Article 22 and by virtue of Article 23 of the Constitution, which now provides this, if you read the act, that's what provides now for you to go to the Mutunga rules. Yeah? The Mutunga rules are specific on how you bring these matters or alleged violations or contravention of human rights or violation of any fundamental freedoms, and it's by way of a petition. That's the reason why in any claim touching on Bill of Rights, touching on violation of the Constitution, you bring what? You bring this. You bring the claim using what? Using a petition. Where you use the statement of claim, it's simple. Now, for instance, an employee has unfairly dismissed you. You use a statement of claim. Huh? An employee has done this to you. You use a statement of claim. You have a labor issue. You use a statement of claim. You have what's it called? Disputes between trade unions and members thereof. Disputes between employers, organization or federation. Disputes concerning the registration. All those issues. Then, based on that, you bring claims of what? You bring claims under the statement. You bring them through through a statement of claim. That's when you would use or typically ordinarily use a statement of claim. Let's say like it doesn't touch on issues to do, violations of human rights and violations. It's just purely issues between employee, employer, trade disputes, all these issues or disputes listed under section 12 of the ELRC. Issues on rights, fundamental freedoms, I will suggest going by way of the Mutunga rules. It's the same way why you wouldn't bring a claim for violation of constitutional rights using a plaint. It stems back to the issue of Anarita Karim Njeru principles. The reason why we have these Mutunga rules, it's because of it basically encompasses the principles that were enunciated in the Anarita Karimi, pleading to a reasonable degree of precision. When you talk about violation of human rights, you have to set out with a reasonable degree of precision. How is it? Which provision has been violated? Which right has been violated? How was it violated? Who violated it specifically? The Mutunga rules through a petition provides for you or how you can bring such a matter. Or how you do that pleading to that reasonable degree of precision. If you do it by a statement of claim, there are dangers. What are the dangers? The dangers are, one, you may not follow or you may not plead. The PO, this guy will just raise a PO that you've not pleaded to a reasonable degree of precision. I'm unable to defend my suit. I don't know how the right has been violated. You end up finding a claim being dismissed. The other thing is based on the fact that the form of the petition is wrong. It's how can I put it? It's you've not adhered to the procedure. Now on the aspect of procedure, there's a way you can go around it, overriding objective and so forth. But the key consideration is, have you pleaded with a reasonable degree of precision? And how do you do that? By following and adhering to the Mutunga rules. That's how I'll say it. So in summary, what I'm saying is, we use a statement of claim if it's any of these matters here under Section 12 of this Act, the jurisdiction, trade disputes, employment, employee disputes, and all those, anything to do with violation of human rights, anything to do with violation of the Bill of Rights, anything to do with violation of constitutional provisions, go follow the procedures provided for under Article 22, Article 23, read together with the other, read together with the Mutunga rules. That's how I would answer the question. So, is that fine, guys?
On the statement of claim, I can add something.
Yes, go on. Go on.
If you look at most statements of claims are usually between the employer and the employee, and you can find in some scenarios, like especially if you use the Shafiweru case, it's not decided, but if you use, you can see he was claiming also for unpaid salaries, or if there was overtime. Those are some of the things. If you see in a case scenario and you see areas that either the employee is claiming that there was some areas he wasn't paid, there was also this is called a severance pay is not catered for, or during the process of him being terminated was not factored into case that can work. That's why you can use a statement of claim. For the petition, I think so long as exhausted everything. That's first thing I would have had that one.
Thank you very much. Thank you very much. Now, somebody please read for me question number 4 so that we move with speed to know if we can finish this thing. Number 4.
Peter has sued Jen in a suit. Peter's claim against Jen is of 1 million Kenyan shillings, which arose out of supply of goods. Jen has failed to settle the said amount. Peter is concerned that when the case is concluded, judgment will be given in his favor. He has attached all relevant documents. Jen already has lawyers who also have filed the relevant papers in court. A hearing date has been fixed 2 months away. While in the course of business, Peter gets credible information that Jen has planned to move her transport trucks to the neighboring country in an attempt to escape justice in the present suit. It is also informed that Jen has no other assets but the trucks. Jen has also been heard stating that she will not settle the money claimed in the suit. Peter is advised that if he does not move with speed, he might not be able to recover the money owed to him. Peter's lawyers have filed the relevant application in court affirming all facts stated above. As a legal researcher to the sitting magistrate, comment on the relevant order being sought by Peter and the rationale behind the orders sought. Advice on the decision likely to be given by court and the reasons for the decision.
Now, thank you for that. Maybe I analyze the question. Somebody is calling. Maybe analyze the question, then give me 2 minutes. Then I get back to you on. You can just discuss. What are the answers? How will you approach question A? Let's begin with that one.
Then issue proceedings.
Mareva injunction.
Injunction.
Yeah, I also think it's a Mareva injunction.
Si ni freeze order hapa, si ni anaitwa.
Yeah.
Hizi mara zake freeze so Mareva injunction.
Yes, not able to transfer, to move suit property out of the jurisdiction of the court.
The rule 2 also speaks about moving to another jurisdiction. You move by that.
I would actually go by order 39 and not a Mareva injunction.
Yeah,
So,
attachment for
yeah.
judgment.
That's attachment before judgment, order 39 from rule 5 onwards. It's not order 39, the beginning one, which talks about arrest, but the second part from rule 5 onwards, which talks about attachment before judgment. Since this guy is attempting to escape justice by transporting the trucks to a neighboring country. So you have to make sure the property is attached, so you fulfill, you are able to recover the fruits of the judgment once it's given.
Nice. Now I'm back. So, what have you guys concluded the answer is on question 4A?
Attachment.
Attachment. Under what provision?
Order 39, Rule 5 onwards.
Order 39, Rule 5. Now, somebody, okay, in light of revising and discussing, somebody explain to me why Order 39, what is Order 39, what does Order 39 provide for? And how do you distinguish that one from Order 40? Why will you use Order 40, not Order 39? I'm asking this because somebody called and asked me that question. And I did some explaining and I promised to repeat it during this class. So tell me, what do you think? Actually, explain to me Order 39.
Hello. Hello.
Go on.
Yes.
Go on.
Yes, the basis of Order 39, which is on attachment and arrest before judgment, is that it is intended to stop the defendant from disposing or of evading justice. Therefore, you can either choose to arrest him, but that's illegal because of Article 11. Remember the Zipporah Mathara case, civil jail. So that wouldn't make sense. So you would go with attachment of the assets of this individual. That's basically it in a nutshell. But my contribution with regard to question 4, meaning Mareva, which the intention is just to freeze the assets of the deceased, freeze the assets of this fellow, of the defendant, so as to prevent the eventual disposing of the assets. Yeah. And then kuna hii case ya DT Dobi. I can't remember it very well, but there's some DT Dobi case. Yeah.
Wow, thanks for that. So Order 39 is broken up into 2 bits. There's Order 39 Rule 1 to 4. There's Order 39 Rule 5 to, what's the last rule? Is it 12, 13? Let me just open it. So basically the gist of the entirety of Order 39 is where in a question, if you see anything to do with this person wants to remove something out of the jurisdiction, wants to dispose of his property, it should click to you, that's Order 39. If you see something to do with this person wants to do what? Wants to abscond or leave the jurisdiction, it should click to you, that's Order 39. So true to what you've said is, this person, Peter, claims against Jane is of 1 million arose out of supply of goods. Jane has failed to settle the amount. Peter is concerned that when the case is concluded, judgment will be in his favor. He has attached all relevant documents. Jane already has lawyers who have also filed the relevant things in court. Peter also gets credible information that Jane has planned to move her transport trucks to the neighboring country in an attempt to escape justice in the present suit. Peter is also informed that Jane has no other assets but the trucks. So in this, you see all the key things are pointing towards this person removing these things out of the jurisdiction in an attempt to defeat justice. So comment on the relevant orders. The relevant order being sought and the rationale behind. The rationale is to prevent an injustice by ensuring that the goods that are subject to the suit remain within the local limits of the jurisdiction of the suit. That's the rationale. The relevant order being sought, attachment before judgment. That's the order. The law on it, Order 39 of the Civil Procedure Rules, and you have the full 3 marks in that question. Maybe is there any question on that? Any other question on Order 39. Now the distinction between 39 and 40, 40 is on injunctions. So if you say anything that's talking about this person, yes?
Solonka.
Yes? Go on. Can you hear me?
Yeah.
Okay, go on. Go on, please. Am I audible? Is it my connection?
Your connection.
My connection is breaking.
Your connection is fine. I think the problem is on the other side.
Okay, that's fine. So that's it to do with order 39. So order 40 is on injunctions. Yes.
Kindly come again on the rationale.
So the rationale is to prevent an injustice whereby you may have litigants who will want to avoid justice by removing the subject matter or removing their goods out of the jurisdiction of the Kenyan courts, out of the Kenyan jurisdiction, so as to defeat justice. If they take these things out of the jurisdiction, what will happen? You cannot attach, you cannot execute. It will be a problem. You may get a judgment, but in the end, you will not be able to execute or get justice. So the effect of Order 39 and the rationale behind it is to prevent these people from taking the subject matter or taking goods or disposing of property that is subject to a suit before the determination of the suit in a bid to preserve or to maintain justice. That's the rationale. The rationale is just from the wording of Order 39 to prevent people from removing the goods or property from the jurisdiction of the Kenyan courts.
Solonka.
Yeah, go on.
Yeah, I had a question. Please help me differentiate between this question about arrest, attachment of goods and garnishee proceedings. I'm really confused. By the time we were reading this question, I thought it is about garnishee.
Oh, okay, that's fine. Okay, now, let's, as I normally do, we read using the law. So, first of all, let's begin with the difference. Yeah?
May I help before we go to the laws? Because I usually have a simple term to differentiate the two.
Yeah, please go on. It's fine. Yeah, go on.
So if the difference, like a garnishee proceeding is, for instance, I am the decree holder, so long as the judgment debtor, and I know Solonka has money in Equity Bank, and that money can satisfy the debt. And Solonka, being the judgment holder, has not finished paying the decretal sum. Using the money in Equity Bank, I shall institute a garnishee proceedings. You go by way of a notice of motion, you institute a garnishee proceedings using Order 23, and you institute that, and you state that you want the money in Equity Bank, which Solonka holds an account there, and you also have to indicate the account number, and so that money can be used to pay the decretal sum or the balance of the decretal sum. That's a garnishee proceeding. For attachment is where how Solonka has explained, you attach the property. It's during the course of the suit, especially when you're going by the Order 39. During the course of the suit, you as the plaintiff, you see that, especially in a liquidated claim, you see that you might suffer a discourse, or you might suffer injustice if these orders are not given. But for garnishee, the suit has ended. You want to execute, and the property has not. There's no area where the judgment debtor can pay directly, but he has money in an account, or it's usually through banks. use order 23.
That's absolutely true. Order 23, garnishee proceedings. Order 39, attachment before judgment. Now, actually, on top of what is added on top of what is talked about, it's also prudent to note what stage do you bring these applications. So, for instance, the application for attachment before judgment, you bring it during the pendency of the suit. Yeah, while the suit during the pendency of the suit. Garnishee, it's a way of execution. Huh? Garnishee, the one that you're talking about under order 23 of the Civil Procedure Rules. Huh? Also known as attachment of debts. So garnishee, this is where is it? Yeah, order 23 on attachment of debts. Huh? So garnishee proceedings are brought. It's like a mode of execution. So you have a decree holder, you have a judgment debtor, you have a bank account that has some finances in it. That some finances or holding finances for the decree, not for the decree, but for the judgment debtor. So you just make an application, as is rightly pointed out, for those deposits or for the cash in that bank account to be attached. It's a mode of execution. So that's attachment of debts. That's a garnishee. Those are garnishee proceedings under order 23. Now order 39, it's attachment of property before judgment. So the difference between those two, other than the ones that have been mentioned, is attachment of property. This person, think of it this way. Person who has a question, think of it this way. You supplied somebody with vehicles, and you transferred the vehicles in his name. Very premium Porsche vehicles in his name. The person fails to pay you. You sue him. In the process of suing him, you hear that this person wants to transfer those vehicles from Kenya to Uganda. Yeah? What will happen if he does that and is successful in doing that? If he transfers the vehicles to Uganda, you will not be able to execute. You will not be able to get back your vehicles. You'll not be able to. There's no recourse. You may get a judgment saying that this person is liable, this person should pay, but this person fails to pay. So during the pendency of the suit, you bring an application for those properties to remain in Kenya pending the hearing and determination of this suit. While garnishee proceedings, after now the court has rendered the decision, you realize this person has money in this bank account. Make an application for those sums to be attached. That's the main difference between the two. And then now we have another application known as an application for security for costs. Security for costs. Why? Somebody explain to me what's that application and how is it used? Which provision is it found under?
If my memory serves me right.
Yes.
So this is basically it basically happens when you're doing appeals. Maybe you want to set aside, not actually setting aside, but when you want to do, setting aside, and in most cases, whereby you're saying that indeed that there is that amount that you have awarded this person, and your client is able and willing to furnish the said amount, then the amount is deposited in a certain account. In most cases, the account by the opposing counsel and your client and you yourself as the advocate. You can open an account and then you deposit that amount in court in that account. So that security is basically saying that, yes, I'm doing this appeal not because I do not want to pay this person. I am just trying to tell the court that I actually even have that money, but I have some very, very valid grounds that I want the court to consider. So I think that is what security for cost is all about.
Good. Now under order 42 rule 6, that's one aspect in which security comes in. So you make a stay application under order 42 rule 6. When you make the stay of execution application, the thing that happens is you have to satisfy substantial loss and you have to deposit security for the due performance of the decree. That is one, the one that is clearly and well explained. There's also another one, security for cost. Let me now mention it here. Okay, it's under order 26. Let me just open it. Then now I want somebody. He's explained the one for order 42. Now I want to hear someone explaining the one under order 26. This one here.
Solongo. For the order 26 one, for security costs, if I remember correctly, it's among the interim orders that are usually sought by an applicant. So the basis of the security for costs arises whereby the plaintiff, there is a suit that is between the plaintiff and the defendant. But now the plaintiff, since maybe he's away or maybe he's not within the jurisdiction of the court, he is mandated by the court or is directed by the court to deposit security for costs, in that account, in a joint interest and in account or in the court's account. Now, for purposes of suits that involve immovable property. Yeah, that's what I remember.
Solonga.
Go on.
Just if I might add to what my good friend George has said.
Yes.
The one we're talking about here is where it's for the protection of the defendant. So it's used for the reasonable protection of the interest of the defendant. Where, for example, a plaintiff resides outside Kenya, where the plaintiff does not have sufficient property within Kenya. So what we're saying is this: yes, you have brought this in court, but you're a foreigner, you don't live in Kenya. And or if you look at the kind of property that you don't have enough property that maybe would use to award cost. So what we're doing is this: yes, you put the case to court as the plaintiff, but we want you to put a security in court, so that in the event that I actually, win this case against you as a defendant, I'm able to recover my cost at the end of the day. So it's for the interest of the defendant in those kind of circumstances. Thank you.
Great. Fair. You've answered the question. So what happens if somebody brings a suit? Well, there are these frivolous people with very frivolous suits. So what happens? The one you've given is for foreigners. That's one. Yeah. Another one will be, let's say, let's say somebody wants to sue a very big multinational corporation, and the suits will have serious devastating effects against that corporation in terms of how can I put it, in terms of like, let's say for instance somebody today wants to go to court to prevent Karachi from Karachi breweries from manufacturing any alcohol. They want to completely stop it, and then maybe even brings an application in court, an application for to stop them from an injunction application to stop them from manufacturing. Like somebody just brings a suit, and this suit in nature, it's used as a bar, like to prevent frivolous or vexatious litigation. And this person, by bringing this suit, it has some devastating impacts or some impacts. The advocates for the defendant, not sure who's making this application. The defendant will make this application. The advocates for the defendant will make an application in court. And this application in court will be to the effect that this person, for this suit to go on, this person has to deposit a sum. And maybe they've calculated under our cost in this matter, the security that we need in this matter, the costs for all these things will be, let's say, 100 million. So for this suit to go on, let this person deposit 100 million in court. If they deposit, the suit goes on. If they don't, then the suit dies at that stage. So that's the application for security for costs. So it's usually done by the defendant, and it's an application that is made basically to tell the plaintiff, in simple terms, layman terms, that here, this is it. You bring this suit, deposit this sum for this suit to go on. So there are certain grounds that you need to satisfy. Now, one of them is maybe the one that you guys have mentioned, foreign entity, doesn't have local offices in Kenya and so forth. That's one. But that in itself is not sufficient. You have to show that these persons are not able to pay. That these persons will not be able to pay ultimately. if this court decides against their favor. They have an example on the issue of foreign. There's a matter I was working on. I was working on at the farm a few months ago, and it revolved around a French bank. So what happened is this French bank had given out over it was a lot of money. It was over hundreds of millions of Kenya shillings. It was even amounting to billions to a certain bank in Kenya that went under receivership. Now, the argument, okay, this French bank brought a suit saying that this bank has to pay us back the money that we send them, so forth and so forth. So this French bank brought this suit against this bank in Kenya that underwent receivership because they want their money back. So what happened is the advocates for that bank, the Kenyan bank now, filed an application for security for costs. And by filing the application for security for costs, they were asking for certain millions for this suit to go on. The court, in rendering its decision, determined and stated that, security for costs in this matter is not necessary. Why is it not necessary? In as much as the plaintiff is a foreign entity, or like it's a bank, it's a foreign entity, it's a bank from France. It doesn't necessarily mean that these persons won't be able to pay or ultimately satisfy any decision or decree or cost that this court may order upon the determination of the suit. Why is it? It's a renowned institution. It's known worldwide. So security for costs is not necessary in this matter. So the gist is that there are certain factors that you need to prove before you bring such an application. So I was just clarifying the issue of security for costs under Order 26. There's also that security under Order 42 Rule 6. And there's also, that's just it. There's also the application for attachment before judgment, arrest before judgment, and application for injunction. So that's it to do with question 4A. And then question 4B, yes?
Yes. Cost that you're talking about, the security of cost that you're talking about under Order 42 is Order 42 Rule 14. Because 6, that security is for the satisfaction of the decree. It's not security for costs. So I think
yes. That's true. Okay, the one I'm talking to, the security that I was talking about, it's the security for stay of execution. So these are circumstances where you want to stay a judgment as you appeal. So you make that application under Order 42 Rule 6, whereby you have to satisfy that you suffer substantial loss, and you will deposit you will deposit a certain security for the satisfaction or the ultimate satisfaction of the decree. Now, there's this other one under Order 42 Rule. It's actually here.
14 thereabout, or 16, yeah. 15. I don't know.
Yes, Order 42 Rule. Order 42 Rule 14. This happens sana when you are appealing, even in the Court of Appeal. So let's say you are claiming, let's say you've done okay, you instituted a case in the what? You've instituted a case in the High Court. Typical case, an adverse possession case. The court doesn't give you the orders you want. You want to appeal. Now, when you want to appeal, the court can order that at any time after the memorandum of appeal has been served, the court can order, but at the same time it's discretionary that you need to give security for any costs of the appeal that may be there. So it may be deposited in a joint security account, and it may be deposited in maybe in the court's account. So it's something that can be a precondition to you filing an appeal, or maybe for you to not filing but executing that appeal, like going through with that full appeal. So yeah.
Okay. So
but then there are certain circumstances you need to satisfy for that. Yes, go on.
Yeah, you were going to give some critical difference between Order 39 and Order 40 before we interrupted you. So okay.
Well, okay. For order 39, we are clear up to that on order 39 on the aspect of attachment and arrest before judgment. Order 40 is just on injunctions. Simply enough, temporary injunctions. So if you see somebody, if you see a fact in the question, so for order 39, what you will see is this person wants to remove this person wants to escape this. Those are the keywords to guide you towards order 40. Order 39, sorry. In order 40, what you need to check are certain factors like this person is destroying, this person is wasting, this person is damaging, this person wants to do this. So you need to dispose him. Huh? So based on that, you bring an application for temporary injunction or intellectual orders under order 40. Now, there's something that people usually what? There's something that people usually, how can I put it? People usually, this order 40 rule, it's starting to get tired. Order 40 rule 1B. Now, somebody kindly distinguish between these because people maybe confuse this thing with the one under order 39. Someone please distinguish. Here. What is the difference between this removing and disposing of property in this order 40 rule 1B and the one under order 39?
Try. I would say that the one in 1B is talking.
Yes.
There's so much echo.
Oh, let me mute. Sorry.
Okay, I'd say that intends to remove or dispose property in that way. But the aspect of jurisdiction is lacking in that sense. Like in order 39, there's that aspect of somebody wanting to move the assets from one jurisdiction to another. But under order 40, that is not necessarily the case. It could be within the country. I'm thinking in that sense of jurisdiction, like jurisdiction being the determining factor.
True. That's the difference. It's basically what you've said. The difference between order 41B is that this one is just removing or disposing. By removing and disposing, inaweza kuwa this person is just wants to sell. Yeah. So maybe it's the dispute was about a certain car. This person goes ahead and wants to sell that car. That's order 40. But under order 39 rule 1, this person is removing or disposing by way of taking this property out of the jurisdiction. That's the difference, as you rightly pointed out. So if the issue is on taking out, ukiona to anything to do with taking out of a jurisdiction, like this person, if you see anything jurisdiction, going out or taking out of a jurisdiction, that 9 should click. Stopping, wasting, alienating, destroying, should click to your mind. That is order 40. So now the other thing is
if you use a notice of motion to in the order 39, just a clarity, just a small clarity.
Yes. Now, you guys learned of interim orders. There are several interim orders you guys have learned about. There is okay, you can list them since you once preparing for this. There is order 40 we've mentioned, order 39. There are 2 interim orders under order 39, arrest before judgment and attachment before judgment. Those are 3. The other one is security for costs. The other one, appointment of receiver. The other one, orders of commission. Yes. Is there anyone that I've left out?
Yes, this is
Yeah, with the commission and all that. So for those, all those applications are notice of motion applications, all of them. Yes.
There's a difference in discovery.
Yes, go on.
Yeah, it's notice to produce.
Yes.
NOM, yeah. So there's a difference there. It's the only one that is different. When you talk about discovery, we have notice to produce. Yeah.
No, thank you for that. Notice to produce. For the others, you bring it by way of an NOM, huh? Notice of motion. So for the security for costs, for the attachment, all, you bring them through an NOM. So up to there. Yes, go on.
I have a question, but it's not on where we are. It's where we were on Ganishi.
Yeah.
Where, say, for example, there's money owed to the judgment debtor, but it's not with a bank. It's not money that is held with a bank. It's perhaps with someone else. So will you still use Ganishi when it's not a bank?
Now, Ganishi is specifically. So it depends. The person that is being held by that other person, is it being held as a debt or not?
Yeah, it is a debt. Someone has money to someone has the judgment debtor's money.
Now, based on that, you see, for attachment of debts and for the bank, it's specifically provided under Order 23 Rule 2. Now, under Order 23 Rule 1, it's saying a court may, upon the ex parte application of a decree holder, either before or after an oral examination of the judgment debtor and upon affidavit by the decree holder or his advocate, stating that a decree has been issued and that it is still unsatisfied and to what amount, and that another person is indebted to the judgment debtor and is within the jurisdiction, order that all debts other than the salary or allowance coming from the provisions of Order 22 Rule 42, the judgment debtor shall be attached to answer to the decree together with the costs of the Ganishi proceedings and by the same or any subsequent order, etc. So the gist of it is under Order 23 Rule 1, it provides for debt specifically, and it's anybody who has a debt to the not the decree but the judgment debtor. Anybody who has a debt to the judgment debtor. That is Order 23 Rule 1. Order 23 Rule 2, now that's specifically to banks. Yeah. Attachment of deposits in bank. Yeah. So the answer is yes. From the reading of Order 23 Rule 1, you can attach from anybody. It's not specifically to banks, but actually for banks, it's a different rule altogether. But for Rule 1 and Order 23, anybody who is indebted to the who is the judge who is indebted to the judgment debtor can be issued with orders or Ganishi orders for them to pay the decree holder pursuant to the Ganishi orders.
Okay, thank you.
Yeah, and the application is a notice of motion. Sawa. Now, there is advice on the decision likely to be given by court and the reasons for the decision. So what is the decision likely to be given by the court and the reasons for the decision? How would you approach this question? So you first said it's attachment before judgment. What is it? Kindly. What are the decisions that will be given and what is the rationale for it? It's under the 39 still. Sorry. Would you guys please assist, or if you can't, I can proceed. Okay, let me proceed then. So the decision that will be rendered in court is, first of all, you know, there is a process. It's not, the person is not like, the property is not first attached. What happens is this: the court will first give this person or call this person to furnish security. This is the first thing that will happen. Yeah. This person will be ordered to furnish security within a specified time frame. That is one. Or the court can order that this person to produce or place at the disposal of the court the said property or the value of the same. Yeah, that is it. Then, if this person now, they don't furnish security, they have not, actually the first thing is, if this person have not shown cause or security, or they haven't given now security, the court will now proceed to make the orders attaching. So are you following? So that's the decision. Those are the decisions that will be made first of all. So the rationale for them is okay. First you need to show cause. Either show cause, furnish security, or produce the property. If you can't, the court orders for the attachment. So the rationale for it. Maybe somebody assists me with the rationale. The rationale I know for order 39 is the entire rationale for order 39 is to prevent the properties from absconding of this guy from avoiding justice by taking properties out of the jurisdiction. Now, what is the rationale for the issues on? What do you think? I think this is something that you should just think on your feet, sitting the example. Or do you think is the rationale for showing cause, producing the property, or furnishing security? And if you don't, then the court orders for the attachment. What do you think is the rationale for that?
So long as I may reply.
Go on.
I think first is to ensure that the judgment creditor is able to enjoy the fruits of the judgment once the court does the same, and to ensure that the court does not issue orders in vain.
Yeah, that can be.
I think also in addition, the rule is that litigation has to come to an end. And in most cases, why you ask to pay, to give security, is so that the court can ascertain that indeed this person is able. If you have money, then most likely, most often, is that you have a very, very valid claim. So in the absence of the security, then the court will just have this perception that this person, by the way, does not have his money, so they are just wasting the court's time to drag the litigation process.
Thank you for that. So that's something you could do research on it, and upon it. Actually, based on your arguments make complete sense, and that's what I will put in the exam paper. Now I'm seeing it's it's 11. Are you guys tired? Should we now call it a night, or we skim through this thing haraka? Question 5. So question 5 is on purporting to be auctioneers, broke into Helen's offices and carried away several items under the pretext of instructions from Anna. So do we do 5 and 6, then we finish, or you guys suggest we call it a night? We just skim through first in the next 10. We finish by 11. Yeah? Or we finish?
Yes.
I believe so.
Yes, finish.
So question 5, people purporting to be auctioneers broke into Helen Chloe's offices and carried away several items under the pretext of instructions from Anne Parker, the decree holder. Helen Chloe confirms to you that there was no proclamation notice served on her, and she is not aware of the existence of civil suit number 700 of 2017, wherein Anne Parker had sought payment of a debt. In the court orders, Anne Parker had applied for an intellectual judgment, which was granted. Helen Chloe confides in you that she owes Anne Parker $1 million, and she has kept her bargain by diligently paying $200,000 as agreed upon on a quarterly basis, and she expects to pay off the debt as agreed in 2 years' time. Give her advice and the process to be taken. How will you go about this? Beautiful. We finish. How will you go about this?
For me,
Go on.
there's a lot of echo.
Let me mute. Sorry. Okay, go on.
would you go back to the question? Since this entails giving her advice, so I think somebody can start advising where they feel comfortable. And so for me, I would start where where the interlocutory judgment was granted. So advising her on how an interlocutory judgment is entered. If somebody does not enter appearance or file a defense, an interlocutory judgment could be entered. So in this case, since judgment has already been entered and they have proceeded with execution, the next advice would be for stay of execution and an application for stay of execution through a notice of motion and setting aside the judgment. And the grounds would be that either she was not served and that she was not given any proclamation notice and all that. All those stories that she's saying would be what I would put in the grounds for the application for stay of execution, as well as setting aside the judgment which was entered. Yeah, maybe somebody else can take over.
No, you've gotten it spot on.
Solonka, would you be so kind as to go back to the question? Yeah, the question, please.
That's the question. I projected it.
Thanks. So, mimi ningefanya hivi swali. The first thing that I've noted here is in the court records, Anna and Parker had applied for an interlocutory judgment, which was granted. That's issue number one. Issue number two is people purporting to be auctioneers broke into Helen Chloe's office and carried away several items, blah, 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 blah. So the first thing you need to note here is that there is judgment that has been entered. And so we'll start this whole story from the part of judgment, Order 21. And I think we'll also touch on a bit on Order 10. Order 10, your failure to...
default, judgments in default, yeah, go on.
So an interlocutory judgment is usually issued with regard to, to what? To when you fail to enter appearance, or you fail to file a defense, or stuff like that, and you have to prove that indeed proper service was effected. So from there, I would do this way. Number one, there is an interlocutory judgment that was entered by Ann Parker. Here we don't dispute on that. However, Ann Parker failed to file a document that is known as a notice of entry of judgment, which is supposed to be filed 10 days prior before she gets an application for execution under Order 22. I think you can 22 Rule 6. I think Rule 6, but not only Order 22. I think Rule 6 or thereabout. I think it's Rule 6. Rule 6 to be precise. You're supposed to get, the decree holder is supposed to get an order for an order, an application for execution, which is by Form 14. So that is the first issue that that's like the first things with regard to the procedure. She gets a notice of and Parker would have gotten a notice of execution. Number one. 10 days later, she applies for execution. And then now upon applying for execution, she ought to receive a court order from the court. Now, after she gets now the order after the application for execution under Order 22 Rule 6, she ought to proceed and get warrants of attachment of the assets of the of who Helen Chloe. So in this instance, I believe these are chattels, these are movables. So she'll be making reference to, I think, on the 8-ish, Rule 8-ish, number 9, around up to Order 22. It's just up to. So with regard to movable properties, then she has to ascertain the description of the properties, to know the value. Hii ni kazi ya auctioneer tu. Auctioneer atafanya hiyo kazi ya proclaim the nini, the the assets, and they have to be coherent with the judgment sum. What else comes up here? So there is this other paragraph on Helen Chloe confides in you that she owes Ann Parker 1 mic, and she has kept her bargain by diligently paying 200 Gs as agreed upon on a quarterly basis. Now this is also something about payment on installments. Now hapa natumia street knowledge, but I remember Mongare once said that when you use when parties agree for payment of installments upon execution, you're supposed to it acts as it's like a stay of execution. Because I remember there are 3 instances of stay of execution. There is the application of self-execution, kuna objector, na kuna your payment by way of installments. So in this instance, it's payment by way of installments. So it ought to have acted as some sort of stay of execution. So it means huyu au auctioneer hawako na they ought not to have gone to ofisi za Helen Chloe kumchota. Ideally, they ought not to have done that. Max ngapi bro?
I've gotten all the marks and extra actually.
She expects to pay off the debt as agreed in 2 years time. 2 years time ni venye wanaongeanga. Hii kuna provision fulani inasema story ya nini ya kulipa kitu by 1 year, but nimesahau. But anyway, yeah, that's my cup of tea.
Brilliant. So you've both gotten it correctly. Beatrice, George, you've gotten it completely correctly, spot on. You get the full marks over there and you pass the exam. So the issue is under order 10 of the CPR, as I am not even going to add anything. Whatever they've said, that's the law. That's the answer to the question. This is an irregular default judgment. Irregular default judgment, how do you do it? You go and make an application to set it aside. Application to set aside an irregular default judgment, order 10, rule 11 of the CPR. Yeah? So you guys have captured everything in that question. I'm not going to add anything. You've gotten absolutely spot on. Higher.
So wrong
question.
Before we proceed, there is a part of the question that indicating that there is an auctioneer who didn't serve a proclamation. Sorry. So it means there is, of course, there is need to stay the execution under Order 22, Rule 22. So I feel like that should also be discussed in this question because the property has already been proclaimed.
Yeah, there's a need to stop it. Like there's a need to stop because there's a judgment. Yeah, there's a need to stay that execution because if you don't, you may go on. First of all, you need to bring this application and a certificate of urgency. If you don't stay it, this property will be sold. Yeah, and even after you get your orders, like you are correct, the judgment was irregular, the subject matter has been lost. Your things have been sold, you've lost everything. Yeah? So, yeah, issue of stay of execution is very important in that circumstance. It was mentioned by Beatrice, and also George mentioned it also. So that's a very good point. Thank you so much. Hi. Now we move on to question 6. Question 6. Jamie has a judgment in his favor. The defendant is supposed to pay 15 million. This is according to the judgment that was rendered by the court. However, the amount that were proved cumulatively at the trial was 17 million. Kendo, the defendant has no problem in settling the amount of 17 million. Both parties agree that the judges are also human and should be given a second chance to correct the judgment. As an advocate representing Jamie, we concur with their sentiments. A, advise Jamie on the appropriate legal mechanism to be initiated and the steps to be taken. B, suppose it was Susie, personal assistant to Jamie, who raised the issues above. Explain whether it will be proper for Susie to initiate legal proceedings to have the judgment corrected on behalf of Jamie, who is still within the jurisdiction of the court. So how will you go about that one? Anyone?
So look, if I may attempt on A.
Yeah, go on.
Yes, this is an issue of the amount, the amount indicated is not correctly indicated. So for that, I'll go with order 45, which talk about review. Review
go on.
Take ethics and clerical mistakes. One can apply to court for review, and also I'll also be guided by section 99 of this Civil Procedure Act.
That's true. So, so you can do a review to just correct it, but the one that points directly to it will be section 91 and 99 on the amendment of judgments, decrees, or orders. Clerical or arithmetical mistakes in judgments arising from any accidental slip or omission may at any time be corrected by the court either on its own motion or on the application of any of the parties. So in simple, they're just asking on section 99, correcting that judgment. And then the other thing is just make an application to correct the mistake. And then the other one is 6B. 6B, suppose it was Susie, personal assistant to Jamie, who raised the issues above. Explain whether it will be proper for Susie to initiate legal proceedings to have the judgment corrected on behalf of Jamie, who is still in the jurisdiction of the court. So how will you go about that one?
Solonka. Part A seems to have quite a mouthful of marks, like 7 of them. I don't know whether you would mind to explain the procedure for that correction of the error apparent on the face of the record.
Okay. Now the reason why I didn't, it's because of time, but what my what my colleague who spoke when answering that question, it's just whatever he said, and he talked about he talked about review in the first instance, and I also added on the application for correcting the error. So under order 45, let me just open it, the one that he talked about. Just open it. Here it is. Here, any person considering himself aggrieved, so forth going, and then let me highlight the place. Here it is. Account of a mistake or error that is apparent on the face of the record. So the process is one. You can make an application to review. The application is application to correct. So the application, I have not done such an application. I will guess it's just a simple NOM. That's one option in which you can go for section 99. It's prudent to mention it there. The other one is order 45. The reason why I didn't go through it as much is because we've done it right now, just a few minutes ago, we're talking about review, because the process is the same. You just do a notice of motion application on account of the mistakes or error apparent on the face of the record. Point out the error that is on the face of the record, that the errors, it's written 15 million instead of 17 million, and then you proceed. Give you sufficient reasons, give appropriate grounds, swear the affidavit, and then you're good to go with that. I think that will be sufficient to get you the 7 marks. Because we've actually gone over and above. We've talked about the section 99. We've also talked about the order 45 with CPI, the one that you mentioned. So both of them are good. So I think that's why I skipped on it. That's fine.
Yeah, it is. Thank you so much.
Okay, now how about part B?
Solonka.
Yeah.
I believe that part B is on locus.
Yes.
Yeah, so since she's just a personal assistant to Jeremy, I don't think she has the locus to, be able to bring this case to court for review. Because again, that part order for the section 80 talks about any person aggrieved. Yeah. Then again, I think Solonka, there's a bit of a difference, because when you come to appeal, if this was an appeal, then a party who was not a party at first to the appeal can actually bring an appeal. If you look at the case of Law Society of Kenya, Nairobi branch, versus Malindi Law Society of Kenya and 6 others. So I don't know if you were trying to confuse us like that, but yeah, in an appeal, it would be different. Thank you.
Thank you for that. That's interesting. I'll actually go and look at the case. But yeah, the issue is on locus. Does this person have locus standard to bring this thing in court right now? Does she have any standing before the court? Who is she before the court? Huh? So those are some of the issues that Part 6B sought to address. So we've come to the end of typical civil litigation paper. So the thing, or the beauty about civil litigation is that it doesn't change much in terms of setting the questions. Today they've tested injunctions, tomorrow is arrest and attachment of judgment. They've tested that tomorrow. The day after tomorrow, they test something extra, garnishi or something of the sort. Huh? That's the difference. That's the thing with civil litigation. It's very easy because if you know and you grasp, you have a grasp of the basics, it's easy for you to pass the exam. Now, the thing about civil, be careful about the drafting. Don't allocate too much time or spend too much time drafting, and then you waste time and you don't answer the questions. Make sure you know how to draft at least a notice of motion. You will find one question on a notice of motion application. That's something that's important. Make sure you at least know to draft chamber summons. Si rahisi ikuje, but at the same time it may come. But notice of motion applications from all those years, there has to be a question testing you on a notice of motion application. Check out on the forms of basic pleadings, plaint, petition, how they're drafted. And this paper, you'll pass and ace everything in the paper. So I think we've come to an end of the session. Unless now you have any questions or any concerns or anything you want to raise, please go on. But other than that, I wish you guys all the best in your exam preparations. I know you got this. I know you'll pass. And I